गाड़ी नहीं आ रही वरना गाड़ी चलती है देख सकते हैं। और हम खड़े यहाँ पे हिंदुस्तान
कोर्ट ऑफिसर
ಹೇಳಿ ಸರ್.
ಅದೇ ಈ ಕೋರ್ಟ್ ಕಾಣ್ತಾ ಇದೆ, ಮೊದಲು ಕಾಣ್ತಾ ಇರಲಿಲ್ಲ.
ಆಯ್ತು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ಇಷ್ಟೊಂದು ಸಪ್ರೇಟ್ ಮಾಡಿದೀನಿ, ಅದು ನೀವು ಎತ್ಕೊಂಡು ಹೋಗ್ಬೋದು. ಬೇರೆ ಲಿಸ್ಟಿಗೆ ಕೊರತೆ ಇದೆ ಲಿಸ್ಟಿಗೆ.
Yes, yes. ಅವತ್ತು ನಾನೇ ವರ್ಷನ್ ಚೇಂಜ್ ನಿಮ್ಗೆ ನೀನು ಏನು ಫೋಟೋ ಹಾಕಿದ್ರೆ
Elect.
Mike.
Wife filed a petition before the family court for maintenance. At the stage of respondent evidence, wife got an amendment of the petition enhancing the 20,000 to 30,000. Similarly, husband filed an application for summoning the document of the employment particulars of the wife is concerned. My application, that is the wife application for amendment has been allowed. Application of the husband has been rejected. I filed a memo before this court. Application of the husband may be allowed. The document may be summoned, the trial may be conducted. Further proceeding has been stayed for a period of 5 years. It is matter pending before the family court. I filed a memo. Husband application may be allowed. Trial court may be directed to dispose of the matter within 6 weeks, 6 months.
For that to know why should we pass an order at the fag end of the vacation? That is the next question.
That is the difficult.
Vacation. There are so many matters already.
Please.
Yes.
The petition.
Which matter? The respondent filed criminal miscellaneous for the arrears of maintenance. I have filed the writ petition challenging on the order passed by the criminal miscellaneous
The order passed.
district court, family court, Kolar.
I understand. When is the order passed?
14/7.
Date of order.
14/7. We filed writ petition
14/7.
14/7/2023.
Then what is urgency now?
I have filed a writ petition for the against
Yes.
ಈಗ ಏನಪ್ಪ ಅಂದ್ರೆ criminal petition ಅಲ್ಲಿ arrears of
What we
maintenance.
heard, please understand, for these unreasonable requests, court will not entertain. Yes,
Civil petition, my lords,
no.
transfer petition, my lords. Wife has filed 125 proceedings in Chikmagalur, my lords. Husband has filed an MC petition in Bangalore. Wife is staying in Chikmagalur. Fresh matter.
What is the urgency? Such matters will come by memo for that.
Without memo, they are not taking.
That's appealing for the petitioner, my lord. I am for the mother, my lord. I am here before this court for the staying of 23/4/2025 for the visitation order and the custody order which is given to the father, my lord, where the father has anger issues and before the trial court during the arguments, my lord, the petitioner was threatened inside the horseshoe. It was mentioned before the court, but still the trial court has ordered in favor of the father, my lord. And father has WhatsApp messages addressing the daughter, minor daughter, as well as the petitioner as bitch, my lord. So this is the conduct of the respondent, my lord. There is an urgency, my lord, to stay the order of 23/4/2025, my lord. 23/4/2025, the date of order, my lord.
23/4.
23/4, my lord. My lord, there is an extreme urgency, my lord. Kindly have it at 2:30, my lord, please, my lord. Because
It can come.
my lord, the order says that, my lord, apology, my lord. Order says that the mother has to hand over the child to the father tomorrow, 29th at 10 a.m., my lord. Because of which I am before this court, my lord. There is an extreme urgency, my lord, because of the child.
Why you were not before the court on 25th, 26th?
My lord, I have obtained the certified copy 24th, my lord.
Whatever it is, we'll have it tomorrow.
My lord,
Where is urgency for lunch motion?
my lord,
You can
end
say
of the
you-
list, my
You
lord.
can say you move the matter, it will come tomorrow, we'll hear. Yet.
My lord,
No, one matter, how many times the court will hear the same matter, one order again, amendment to the same order? What is the amendment that you're seeking now?
Meet the children in the presence of one of my relatives, my lords. None of the relatives are ready to come because my
One of
wife
the
has
relatives
been,
are not ready to come.
my lord, my wife has been sending legal notice to whoever I have been in touch with. And she has been sending WhatsApp messages and threatening
So who
them.
will be the third party? Some third party has to be there.
My lords, I am allowed to meet.
Advocate.
My lords, I am allowed to meet in the lobby. There are all CCTV coverages, my lords. It is completely covered. So it is very safe, my lords.
Now, duration was also granted as you wanted. Why not your counsel be there? Your, that third party, any third party, that is what it is. So no amendment is required for that, yes.
My lord, two case HRRP, my lord, placement, my lord. Respondent side HRC is order, my lord. Execution mood, my lord, 26/4/2 and 25, my lord. Saturday is warrant moval.
When
Executor
is the order passed in the?
26/4, my lord, execution warrant.
What execution? When was the order of eviction?
Eviction, my lord, 2 and 24, my lord.
Then what were you doing? till now?
Execution mood, my lord, HR.
Till execution is moved, you will not see.
Respondent execution mood, my lord.
I understand. That's what
My lord, anytime police protection, respondent,
He will do that if you don't get the
house
stay
property,
order.
my lord. My lord, matter is urgency, fresh matter, my lord, HRRP, my lord.
When did you file?
My lord, 3 days file, my file.
What were you doing for an order of 2024 in 2025? You are supposed to move or not?
My lord,
No.
matter urgency, my lord, anytime house property is police protection,
Understanding what is the
recovery, my
question
lord.
of the court?
My lord, matter urgency, my lord, request. My lord.
Court's query, you understand or not? What
ma'am.
were you doing for an order which is passed in the year 24, 25 April before the vacation?
24 is HRC, my lord. Another case filed execution, my
That is
lord.
the impugned order.
26 for execution warrant.
You are not before this court on a warrant issued in the execution. You are before this court on an order of eviction, is it not?
Eviction is 26 for, madam.
First of all, you are not clear on facts. Please find out the facts and then make a mention. Then we will see. Which is the impugned order? When is that impugned order passed? If it is passed in the year of 24, what are you doing till today? And why should the court grant permission today when there are already 170 matters in the list?
Tomorrow.
No tomorrow, unless and until you tell the facts.
Kind submission, my lord.
Yes.
My lord, we are for BMTC, my lord. The respondents already moved to the lower court and attained the attachment order for moves, my lord. Kindly post it for tomorrow. Already this is the third time we are moving this matter, my lord. But 2 times, ma'am, my lord already allowed the memos and posted for yesterday, my lord. It not been posted before this honorable
The
court.
matter in the list already, BBMP.
No, not this one, my lord. But this is also same time it was moved before this honorable court, my lord. This is the third time, my lord. Kindly for tomorrow, my lord. For the stay, my lord.
Which is the case?
MFA 1731 of 2025, my lord.
It's already listed case.
No, it's not listed, my lord. Still.
There is a matter in the list.
another three more matters, my lord. Again, same appellant has been, respondent has been moved for attachments, my lord,
Take that
for tomorrow, my lord. Much obliged, my lord.
tomorrow.
Lord,
Yes.
submission. First serial number 19. Council on record is not well. Kindly have it immediately. Serial number 19. We are for the petitioner, my lord. He's not.
Have you informed the other side?
Lord, there is no other side, my lord. It is not at
It's coming up with the first one.
Yes, my lord. He is not.
Then we'll order notice in that.
Please.
19, notice to the respondent.
Yes.
Yes.
Please.
Serial number 21, list 2, for the petition.
Let's do.
Yes, madam. Only 1 week time granted, my lord.
Serial number 19,
21.
21.
Kumar TM.
Yes.
Hmm.
Serial number 10, my lordship. List
Only
2.
1 week time, my granted, my
You appear for whom?
petition.
You have a stay.
Yes,
Non-filing of affidavit by advocate for,
but not concern my client, my lord.
I think this came up on the last occasion also. Have you informed the other side?
Yes, my lord. Senior
And
inform.
right.
Senior info. I will say senior inform the other side.
At the request of learned counsel for the petition list this matter after vacation, it is submitted that already the other side is informed. Yes.
Serial number 10,
Serial
my
number
lordship.
36.
Call it page wise, otherwise it will go on.
Page-wise adjournment. Huh? Page-wise adjournment. List number 1. Serial number, page number 5, serial number 26, 27. Page number 8, 28 to 34. List number 2. Page number 4, serial number 18 to 24.
Yes.
My lord, serial number 13, my lord.
But I am appellant, my lord, in this case.
18.
13.
13, serial number 13, my lord.
18, what do you want?
Immediately after getting some more document, getting this more document. He is guarded.
Have you informed the other side?
Inform.
BB Siddaramaiah.
Huh? You have no objection?
No, I am not the serial number 18.
Yes, 18 after vacation at the request of learned counsel for the petitioner.
Respondent.
Respondent.
My lord, serial number 13, my lord.
I am appellant, my lord, in the serial number 13. I have served copy to D. Vijay Kumar sir, my lord. He has received.
I'm going to file wakalat, my lord. Kindly call after vacation.
Serial number 13.
Yes, my lord.
Furnishing of so and so.
Now I have received it, my lord. I'll send it to the company.
First respondent is Vijay Kumar. Then why this?
Because I have not received the copy, I have not filed the wakalat, my lord.
No, when already
No.
R1 is Mr. Vijay Kumar is there for R1, why again it is coming up in the same caption?
My lord, because I have not filed wakalat, your lordship has once again ordered for issue of.
I have not ordered. Huh?
Then there is an order, my lord. Kindly see.
It is submitted that Ms. D. Vijay Kumar will file wakalat in this matter. This is matter immediately after vacation.
Please, ma'am.
Much obliged.
Yes.
My lord, I want to make a one submission, my lord. My lord, I want to make a one submission, my lord, in list number 4, my lord. My lord has already heard and made the calculation, but there is a calculation mistake. That is, instead of adopting 18 multiplier, 16 is to be adopted because he is a deceased was age 31 years. Suppose I will try to attend the case when the case.
No, you have to be there when the matter is called. You cannot tell the court that you do something when list number 4 reaches. That's not the way. You have to wait.
Page
Yes.
number, list number 2, page number 5, serial number 25 to 34, page number 6, 35 to 36.
My lord, serial number 36, my lord. My lord, serial number 36.5, I am for the respondent, and
Only
36.6.
connected matters.
L. Shrikant
Please,
Rao.
You can see. We will-
I am the appellant. My lord.
It's a case of fraud. You
Lord.
also heard the matter.
My lord, I seek short accommodation, my lord, please.
I oppose for any adjournment in this case.
Page number 7, serial number 37, 38.
So in all other matters, notices are served.
Yes.
We'll hear those matters.
No, your lordship has heard the matter.
But then why is it adjourned?
Milord,
The other side took
Milord,
some time.
I am seeking adjournment for.
How
there is
many
an-
times you will seek adjournment?
No, only one time, Milord.
Your lordship has.
Only one
No,
time.
which matter you are referring?
Milord, I am serial number 36.125. I am for the respondent. 36.6211. I am for the appellant.
Hmm.
Please, I am seeking adjournment. Milord. Some inconvenience.
Even on the last occasion also they were not
Last time
there.
your lordship has.
Last occasion, my senior is there.
Then-
Your lordship is.
Because the court is going to dismiss your appeal, allow their appeals, now you want time.
No, Milord, no.
In fact, the matter was heard by this
We will,
Please.
yes. For the rest,
List number 1. Parted matter, serial number 1. Assignment Bharadwaj.
May I seek a
On a
pass
mother,
over?
my lord.
Senior counsel is on her legs, my lord. Senior counsel is on her legs, may I
In
request for a
fact, that
pass over?
report has come. I mean, I don't object to a Passover. I don't have a difficulty. My lords can take it anytime, but that report has come. If my lords recollect.
court has come and I asked the copy to be given to.
Yes,
all.
yes, in fact, we have
You've
seen.
now only
Yes.
what has to be decided.
Now, as per
is-
the report,
No, what has to be decided now is, during the visit, another 7 or 8 sessions.
They have
or 6
recommended.
sessions to go.
They have
So
recommended.
in that time, what about the visitation of the father is the only question.
Yes.
Now,
Now,
the senior counsel letters will only clarify that and we'll have the matter after 8 weeks.
yes,
After
yes.
that,
I
8
also want to
sessions.
make some submissions on
Yes.
that. It can be taken anytime. Will
Yes.
my lords take it after this round or at 2:30, my lords? Whatever is convenient to you.
No, if she comes, we'll take it up.
Very well.
Both of you are there. Yes.
Please.
Serial number 2. Rupesh Kumar.
There is no representation on behalf of the petition on 25/4/2025. This matter was directed to be listed in the caption for dismissal today. Today also there is no representation. Accordingly, dismissal not present.
Serial number 3. Serial number 3. Manoj Kumar.
Appealed by the insurance company. Office has raised an objection saying that.
The seal is with regard to the insurance company.
Please, Your Honor.
The office objections or overruled notice. Next,
Serial number 4.
if all other office objections are complied with, issue notice. Yes, 4.
4.
For petitioner.
Malesh Papa.
WP ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. I will convert the case. RPFC I filed.
It's an interlocutory, interim maintenance you have
Internet.
against the interim maintenance granted with the family court. The present RPFC is filed and the office has raised the objection with regard to maintainability as against an interlocutory order. RPFC is not maintainable. The office objections are sustained and the petition is at liberty to convert it into a writ petition. Within Kannada, convert it into a writ petition within a week.
Serial
Yes,
number
next.
5. Anand Mutali.
Appear for the petitioner, my lords. All the office objections are complied. There were 2 objections regarding annexures C and D that was not legible copy. We have furnished the legible copy and they asked for manual scripts of all the documents. There is no typed copy as such in the documents, my lords.
Legible copy of annexure CD to be furnished.
Yes, my
Typed
lords.
copy of the manuscript portion of
All.
annexure D to be furnished. Let's see what it is.
Yes, my lords.
Give that. Page number, annexure D.
118, my lords. 118.
Where are the annexures mentioned? Annexures also not mentioned.
It's mentioned, my lords, 188 page number, annexure D. There are 3 volumes, my lords. 188. One eight eight.
What are all these volumes?
My lords, these are assets and liabilities of both the parties, my lords.
And you submitted that the office objection with regard to annexed legible copy of annexure C and D is complied with.
Yes, ma'am.
Is complied with. Then when it is, the second objection is typed copy of the manuscript portion of annexure D to be furnished. The council has made a submission that they are not laid on manuscript pages. The office objection as far as typed copy of the manuscript portion of the annexure D to be furnished is overruled. Yes.
My lords, notice, I may be permitted to take a notice on the counsel in the lower court, my lords.
Summons the counsel appearing before the trial court and file a memo to that effect. List the matter immediately after the memo is filed. Yes.
My lords, a date may be fixed.
I said it will be listed immediately after you file a memo.
Please, my
Question
lords.
number 6,
Yes.
Vinod Kumar M.
My lord, only office objection is that, my lord, typed copy of the order sheet is not furnished. My lord, the order sheet is in typed format only, my lord. Every entire order sheet is in typed format, my lord. Therefore, my lord, I pray for.
It's objection in every typed copy of manuscript portion to be filed.
Half.
Nothing is there. Even when it is not there, they are raising that objection. When you write something, you have to file a typed copy. When that is not there also, mechanically in everything, typed copy of the manuscript portion. In this, where is the manuscript?
My lord, page number 58 onwards, it's the order sheet, my lord.
What is it again for the
Only
50?
8 onwards, my lord. Annexure B, my lord. This is a typed copy of the order sheet, my lord.
This is the copy. What they are referring to is,
Yes, my lord.
wherever there is something is written.
Yes, my lord, please. My lord, the prayer is only for speedy disposal of the petition. That's all, my lord. Limited prayer for that, lordship may convey.
But everything rules are rules.
True, my lord. I agree, my lord. My submission is that this is the case.
Objection. With regard to the filing of the typed copy of the manuscript portion. Then what about other things?
Only one objection that
Jurisdiction to be stated.
226 and today. I'll do it today itself, my lord. In the meantime,
Synopsis to be in chronological order.
I will comply.
There's so many. Do all that. As far as objection number 4 is concerned, is overruled. Other objections shall be complied with.
My lord, in the meantime, may I take notice? Please, ma'am.
Yes, next.
Question number 7.
Yes.
My lord, I am for the appellant in the connected matter. My lord, the serial number, first item, my lord, is not connected with this case, my lord. And other two matters, 7.1 and 7.2 are my matters were appearing and they are connected. First matter may be delinked, my lord.
First, Lord, instead of 6301 of 22, wrong case has been tagged, my lord. There are two appeals, my lord. One is with respect to the present appeal at serial number 7 is filed by the owner of the vehicle, and for enhancement the victim has filed that is MFA number 6301 of 22. The same case was given for to be tagged along with, my lord. However, 7.1 and 7.2 have been wrongly tagged along.
So 7 has to be delinked from 7.1 and 7.2.
7 point.
And it has
Yes,
to be
along with MFA 6301 of 2020.
right. That's why always I ask the advocates to write on a paper and give. If you orally say this is what happens.
6301 now.
Tag, delink MFA 7 from 7.1 to 7.2. List MFA 453 of 2023 along with so and so. Then I number 1 of 23 is filed to condone the delay of 228 days in filing. In case the, uh, the, the owner of the vehicle is successful in this appeal, he has to bear the interest for the 228 days. Next. What about the other matter, 7.1?
My lord, in this,
1.1 may be called after vacation, my lord.
in 7, my lord, I filed an application for stay, my lord. There's an execution petition that has been filed by the
2023 MFA.
My lord, I was placed ex parte, my lord. Then what happened was when the MFO was filed, my lord, MFO was filed, my lord. The court fees was wrongly deposited.
You're doing an exercise on that from 23.
My lord, the order sheet may be seen, my lord, because since then the orders have been passed with respect to the court fee and statutory deposit. The court fee, the statutory deposit was deposited in the instead of court fee, my lord. Henceforth, I have sought for direction and IA number 1 of 23.
All this is required. You are supposed to do what you are supposed to do.
Please, my lord, by oversight, the issue had happened, my lord.
You keep quiet from 2023 and suddenly now you ask for a stay. Why should the court hear that?
My lord, the only grievance was because of
100% of the amount, then we will grant for what you did.
My lord, it was bona fide, my lord. There was
What bona fide?
My lord, there was bona fide, my lord.
What
it was
bona
not,
fide?
my
Let's
lord,
see.
the
What
order.
is it? How many order sheets
My lord,
were
the-
heard for this appeal?
My lord,
It's coming up from 2023. When
my
you're not showing any interest, why should the
My lord.
courts be so generous to
my lord,
you?
apologies, my lord. My colleague who was,
It's not apology. It's not about apology. It is about the manner in which you are pursuing the litigation.
my lord, henceforth, no such delay or anything will be done from the appellant side, my lord. My submission may be noted, my lord. Please, my lord. And they have also sought for enhancement, my lord. Henceforth, may be tagged along.
I number 1 of 23 is filed to I number 1 of 25. What is 23? What is
My
25?
lord, second IA is with respect to a direction where I sought for refund of court fee. On the earlier date of hearing, the same was allowed, my lord. The said application may be not.
Fine. Seeking a direction, it is submitted that due to various reasons, the said IA has not come up for hearing and now the execution is filed. The appellant shall deposit 50% of the awarded amount and the amount within 8 weeks. And the claimant is at liberty to withdraw the same,
Much up.
which is subject to the result of the appeal.
Much up.
Yes, next.
My lord,
What
this
about
appeal is by the
7.1?
insurance company. My lord, this appeal is by the Cholamandala Insurance Company challenging the negligence and quantum of compensation. Though the police have filed a charge sheet against the driver of the auto rickshaw, the entire liability is fixed on the lorry.
Now, 7.2, IA number 1 of 21 is filed to condone the delay of 516 days. So if you look at it, if it is a claimant's appeal on condition condone, even if it is a owner's appeal, then also the same. Then 9, admit post for final hearing.
Serial number 8.
My lord, serial number 8, my lord.
Yes.
E. Vijay
My lord,
Kumar.
this appeal is by the Cholamandala General Insurance Company challenging the negligence, liability, and also, my lord, question of limitation. Accident is of the year 2019, petition is filed in the year 2023 after the commencement of Amendment Act. My lord, police have filed a charge sheet against the driver of the auto, liability fixed on the driver of the lorry.
This is decided on 19/12/2024.
Yes, my lord. The claim petition is filed in the year 3/1/2023 after commencement of the act, that too after 1 year, more than 1 year. They have to file, they should have filed within 6 months. Apart from that, my lord, the charge sheet is against the driver of the auto and liability is fixed on the lorry.
Why there is no delay application?
My lord,
Why there is no delay application?
that they have not considered. Court is not considered.
Why there is no delay? When is the order passed?
On 12,
IA
11,
is not necessary since appeal is in time. How it is in time?
no, I am telling you about the claim petition, my lord. Claim petition before the tribunal.
I am about the appeal and when is the order passed? When is the appeal is filed?
Please, ma'am. My lord, the judgment of the trial court, my lord, is on 19/12/2024. The appeal is filed on 4th April.
How many days?
My lord, the court has calculated, my lord, kindly see the behind the this thing, my lord. Presentation form or index, they have calculated it.
It is submitted that the insurance company is on the quantum on the liability and though the charge sheet is filed against the driver of the lorry since
Auto, driver of the
auto, the liability is fixed on the insured
lorry.
Considering the same, they shall be stay of all further proceedings on the condition that 50% of the amount shall be deposited by the insurance company and that 25% of the set amount can be withdrawn by furnishing the security, which is subject to the.
My lord, there cannot be any liability at all, my lord.
We'll see on security. Yes, 9.
Before the tribunal or high court, my lord? High court?
Before the tribunal. IA number 1025. 25. No orders are necessary. Dismiss.
Cell number 9.
My lord, is appealed by the insurance company.
9 Chandrasekharaya.
Claimant appeal for enhancement, my lord. Please to
Notice.
Please.
Which is the insurance company?
Royal Sundaram, my lord. Royal Sundaram.
Ayal Sundaram.
Where is the list?
Right.
Mr. Ravi S. Sampati is directed to take notice on behalf of the respondent.
R1 may be dispensed.
And please read that to print his name. Note a memo is filed seeking dispensation of notice to R1 dispense with at the risk of appellant. Then what is that? The delay is how much? IA number 1 of 25 is filed to condone the delay of 41 days. For the reason stated, the delay is condoned. Admit post of final hearing. Call for the DCR. Next. 11.
Cell number 10.
My lord, serial number 10, my lord.
10.
My lord, this appeal is by the Cholamandala.
470 days on condition. Yes.
My lord, this appeal is by the Cholamandala Insurance Company. My lord, though the police have filed a charge sheet under section 31 and 181, there is no DL. Still, the liability is fixed on the insurance company.
Pay and recover is
Also,
not
we are
ordered.
denied. There is a delay of 4 days in filing the complaint. Also,
pay
we
and
have
recover
denied.
Pay and recover is not ordered.
That is not been ordered. Pay and recovery is ordered, my lord. Pay and recovery is ordered.
Ordered.
But there is a delay of 4 days in filing the complaint. We have denied the very involvement of the vehicle.
It's so difficult to follow.
Sir, whether pay and recovery is ordered.
Yes, it is ordered. It is ordered, my lord. It is ordered. Pay and ordered.
Then if the DL is not there, pay and recover will be ordered. What else you want?
My lord, we have denied the very involvement of the vehicle.
Let us see what are the grounds. Please come to the ground.
Yes, please, my lord. Kindly. Ground 5, my lord. Sorry, ground 5, my lord. It's not 1 minute, 1 minute. Ground 4, my lord. In the bottom.
The appeal is filed questioning the negligence. Negligence stated that the driver of the insured vehicle was not negligent. Considering the submissions, they shall restore all further proceedings in the condition that the insurance company shall deposit 50% of the amount and the when the claimant is at liberty to withdraw the same. In this, no security is required.
My lord, there is, the owner has to appear, my lord, but then only we can.
No security. The notice. Within, these are all 8 weeks. Yes.
Till number 11, Vijay Kumar.
Claimant appeal for enhancement.
Notice. Which is insurance company?
My lord, R2 is the ACO insurance company, my lord.
Huh?
ACO General Insurance.
Auto.
ACO.
Who appears?
B Pradeep.
Huh?
B Pradeep.
Pradeep.
B Pradeep.
Huh?
B Pradeep.
Pradeep. Pradeep takes notice. What is that insurance company?
Appo,
AC.
ACO General Insurance.
ACO General. The so and so takes notice, then counsel the petitioner. Appellants serve the copy of the appeal memo on the counsel. And what about the liabilities on whom?
My lord, liability on second respondent insurance company, my lord. R2 notice may be dispensed.
If you give, then the court will.
Please, I will
You
give
have
it.
to file for that dispense with.
Please, I will give
So and so, a memo is filed seeking dispensation of notice to
R1.
R1.
R1 dispensed with at the risk of appellant. Then IA number 1 of 25 is filed to condone delay of 188 days on condition. Admit post of final hearing TCR.
Number 12,
In this case, a pain recovery order has been passed, my lord.
Owner is
Notice has to go.
same insurance company. Which insurance company it is?
My lord, ICICI Lombard General Insurance.
ICSI.
Lombard General Insurance Company Limited. Respondent number 2, my lord.
Mr. BC Shivanagoda is directed to take notice on behalf of the insurance company. Notice to respondent number 1.
Please.
Next 13.
till number 13,
Appellant, my lord, claimant appeal for enhancement. Only sole respondent KSRTC, my lord.
KSRTC. Who is the counsel?
My lord, HR Renu.
HR Renuka is directed to take notice on behalf of the respondent. The appellant shall serve the copy of the appeal memo. IA 1 of 25 is filed to condone the delay of 442 days. Same on condition. Admit course of final hearing.
Please.
Yeah.
Please.
Next.
cell number 14,
My lord, this appeal is by the Reliance General Insurance Company. My lord, though the advocate has appeared, my lord, due to some reason he has not filed written statement, also not cross-examined, my lord. Therefore, my lord, an ex parte judgment has been passed.
He submitted the executive with the ex parte judgment. The present appeal is filed by the insurance company. Considering the submission, they should stay of all for the proceeding. Same 8 weeks in this matter on condition on punitive security to withdraw. Yes, next 15.
notice to. Cell
Yes.
number 15, D. Vijay Kumar.
My lord, this appeal is by the my lord, insurance company, my lord, challenging the negligence. 3 vehicles are involved in the accident, my lord. And our vehicle is not involved.
Dispensation of
I am ready to deposit 50% of the.
dispensation for production of the certified copy of the judgment. The IA is ordered for the present, and the IA is ordered, and the dispensation of production certified copy of the judgment for the present. That's in this also 50%. What is on what ground you are before the court?
My lord, 3 vehicles are involved in the accident. Our vehicle is not involved. And the scooter on the Tata Sumo.
IA on furnishing security. Yes, please.
Much.
Cell number 16,
16, please, my lords, appear for the respondent. My lords, they have, my lords, furnished a copy without even providing the annexures, my lord. They may be directed to furnish a copy of the petition, my lords. It's
Who
not
has
even
moved the
paginated.
Who has moved the memo?
They would have moved the memo, my lord.
Presentation for the petitioners. This is matter after vacation.
Great.
cell number 17,
Grateful.
17,
And for the respondent
No,
and
no.
petitioner in the connected matter, my lord.
I am for the petitioner in
Lord,
this
he
case,
was
my lord.
asked to submit the, my lord, serve the hard copy. Kindly see, my lord, on the online, no index, no annexures. They are made to, my lord. I
Everything
could have
was
filed the objections and, my lord, I am passing on the
After
which
vacation.
grateful.
In this case, my lord,
After vacation.
cell number 18,
Yes.
Here for petitioner, my lord. There is some urgency because there is an arrest warrant issued, my lord, against the petitioner.
This is an ex parte order.
Arrest warrant will be issued if you file an appeal
This is a-
petition after 1032
So
days.
this is
delay.
an ex parte order passed in the year 2021, my lord.
Come to know.
I came to know very recently when
How
execution,
recently it is? Where is the affidavit in support of the condoned delay petition?
ex- uh, execution petition may kindly be seen, my lord.
Not execution, come to the affidavit filed by you.
My affidavit is at page number 224, my lord.
220,
224.
read, what are the reasons?
I state that I have not received the summons in the above mentioned case before the learned trial court. I say the respondent has
To
deliberately,
receive the summons, there should be a date, isn't it?
during the filing of execution petition, madam. I'll just bring facts to the, there are two cases, madam. I'll just a minute.
Affidavit, I'm talking about your affidavit. Your affidavit should disclose. An IA for condonation is not a formality unless and until you state the reasons. Now, when you
I
say-
stated the reasons.
No, you should say, when I received the summons, when you have received the summons, there must be a date on that. That should have been stated in the affidavit.
I'll just make one submission, madam. There are two petitions, one for divorce, one for this 125 proceedings. That has been set aside.
That submission should be there on record, not oral submissions. When a condoned delay, what is the purpose of filing a condoned delay petition?
My para number
And
5 may kindly
now
be
I am prima facie not convinced with this condoned delay, with this application file. There are no reasons to condone. Once what follows then? If there are no reasons to condone, your petition should go.
No, reasons are there in para number 4, 5 and 6, madam.
You said 4.
4,
That
5
it
also and 6.
can't be that kind of an affidavit. When the delay is not 10 days or 20 days, just to say that.
No, this is an ex
I
parte
was
order. The MC, I'll just make one submission, madam, for a minute. There are two petitions filed, one MC for divorce by the wife and this 125
Yes,
proceedings.
no, I have to understand that.
Petition has been produced.
Not the petition. What you should state in this affidavit, all these things.
My lords, for
Without
a minute,
stating
may
it,
kindly
file
receive,
some affidavit and you
may
want the
kindly
court
see
to
page number
understand.
48, my lord, for a minute. Page number 48. Ex parte judgment was passed in MC number. Divorce was obtained. Immediately after 90 days, she remarries. This also, she obtains an ex parte order of 30,000 per month. This order was never within my knowledge.
That I understood.
Then I filed.
You came to know about this in the execution.
Yes.
When was the execution?
Execution petition was filed in 2025, this year.
2025, there are so many months, so many days.
I have a copy of online copy, madam.
That's not the way you make submissions, Mr. Counsel.
Execution 9/2025.
Yes, that's what I'm saying. 2025, 9 means that must be in the month of January.
Yeah, month of.
When you have received the notices.
I have received notice. I
Someone
appeared
when-
on 4/4/25, my lord. 4/4/25 I appeared before the trial.
Then who stopped you from saying it in the affidavit?
The divorce decree has been set aside. What happens is, my lord, after divorce has been passed, immediately after 90 days, after expiry of 90 days, she remarries. Then then she files an execution petition to recover the alimony amount. That time I come to know about that execution petition in the year 2022. In that execution petition, she never says about this order.
Because
Then
that
I
is-
filed-
That is with regard to the permanent alimony. That is with regard to the interim maintenance.
Then I
Now-
filed.
Now,
Yes.
whatever it is, she's entitled for some amount as interim maintenance.
No, she has remarried. She has remarried.
When she remarried,
She remarried immediately, man. She got decree on 22/7/2021. 14/11/2020.
but the proceedings initiated for the maintenance. That is what is the
Maintenance proceedings was initiated in the year 2020.
2020. So at least for that 1 year or till she gets married, remarried, she's entitled for interim maintenance.
For 1 year, whatever is there, reasonable
What
amount.
is the amount for 1 year?
30,000 has been ordered. 30,000.
30,000 for 1 year. How much it is?
It will be
3,60,000.
3,60,000. Some 20% of 3,60,000 I'm ready to pay. 20-30% or something. Because he has absolutely no income. I have produced his ITR returns also, which is at page number 250.
What is his salary per month?
His income is 3,60,000.
it is submitted that
3,60,000 per annum, my lord.
passed, and with that he came to know when the when the summons were issued in the execution case. It is submitted that after obtaining the decree of divorce, she already remarried, and for alimony one execution is filed, and for this my interim maintenance that is granted, another execution is filed. Considering the
That has been set aside.
Huh?
That has been set aside,
And
and MC is still
considering the
pending now.
of the land council for the petition, they said this way of all further proceedings in so and so on the condition that the petition shall deposit an amount of rupees 1 lakh within 4 weeks. 4 weeks,
May humbly request for 6 weeks, my lord. May humbly request.
6 weeks. These fees directed to issue notice with the amount, if he fails to deposit the amount within so and so, stay granted with this court stands vacated.
Before the executing court, deposit.
On such deposit, the wife is entitled to, the wife is at liberty to withdraw. Next,
Subject to the petition.
subject to the result of the petition.
Cell number 19 adjourned, cell number
Subject to the
20.
result of the petition. Yes, next.
20. Puneet BS for petitioner.
This case appear for petitioner, husband's appeal, my lordship.
Hmm?
Husband's appeal, my lordship. There is a delay of
What is he doing from 9-18 days? You are waiting till from that day, notice to the respondent.
peace.
Cell number 21.
Your Honor, I am the respondent in serial number 21 appearing through video conferencing, Your Honor. And in 21.1 and 21.2, I am the petitioner, Your Honor, seeking direction in 21.2.
This honorable court asked the locker to be opened. The locker was opened, my lord. There was nothing found in the locker. I am filing that affidavit, my lords. Then in front of the settlement, my lord, the court had directed me to give a fresh terms of settlement. My client, because of his torture, wants to give a divorce without even seeking alimony. What more can I expect, my lord? He has taken away all the jewelry. My client, I have already shared the copy with him with the terms of settlement. Now still the matter is being went on, and there is a direction to pay the maintenance to the daughter. That also is not paying. He undertakes before this honorable court, he is not paying that also. Where should the mother and wife go? He has got all the points to tell against me, but there is nothing.
Yes.
Your Honor, the submission made is totally false, Your Honor. I have, on the last occasion, I have already paid a DD of 2 lakh rupees on the date, Your Honor, 20th of March, Your Honor. And the matter was listed in the family court on 19th of March, Your Honor. On 19th, I have paid the 2 lakh rupee DD. On 20th, I have also
What has happened to the settlement?
Your Honor, the settlement, I have not received any copy of the settlement which the opposite party.
Now the council is submitting that she doesn't even want to have any alimony also. What is the difficulty then in granting divorce? And
Your Honor, I have no difficulty, Your Honor. She has made a claim in her affidavit pertaining to the locker, Your Honor, in which I have not received the settlement copy, Your Honor, at the first, Your Honor.
No, what is the case?
Filing a copy also. I am not expecting anything from him.
Yeah, take that.
Your Honor, this may kindly be recorded, Your Honor, and I am ready to, my side also, Your Honor, I am ready for the settlement if that is what the submission is, about which I am coming to know today, Your Honor.
This entire maintenance comes to how much?
I made it very clear, but I don't want anything from him.
No, there is the petitioner submits that the respondent shall pay the entire maintenance as has been awarded. Shall pay total sum of rupees 15 lakhs to the daughter as full and final settlement.
I sent it by email and also to WhatsApp to him.
Your Honor, no, the email I have received just today morning at 10:30 and the attachment does not open, Your Honor. It says it is corrupted. No WhatsApp I have received, Your Honor. It's a false submission. No WhatsApp I have
For
received.
everything, don't say a false submission, sir. You can say that something is right or wrong. Why false every time?
Your Honor, because
Please listen to the court, mister. No,
Yes.
What about the daughter? Now, if the divorce is obtained and the mother is having the custody of the child, what are you going to do? What are you going to pay for the daughter?
Your Honor, as agreed by the petitioner herself that she is willing to settle the matter for 15 lakhs, which I'm supposed to pay to the daughter, Your Honor, I'm agreed for that amount because I had proposed an amount of 13.5 lakhs.
He undertook before the court of the last date, my lord. Your lordship may kindly peruse the order sheet, my lord. He said he'll pay the amount on next date. He has not paid it. He paid 2 lakhs.
Yeah.
He's undertook to pay the balance amount. He has not paid.
Your Honor, I had made an undertaking that I'll pay another 2 lakh rupees.
I have not touched issue in the settlement, this thing, my lord. Regarding maintenance, if he wants to quit in one, earlier he had come up to 8 lakhs when your lordship tried to settle the matter. Let him pay the child education also. He doesn't want to pay anything. He doesn't want any responsibility. And my client is ready to give him a divorce straight away without any alimony. And crores of worth jewelry he has taken away. I am filing an affidavit. The locker is empty. He has opened it alone without, in the absence of my client, met thrice. When the bank lock was opened, my lord, he said the locker is, key is lost. The lock was broken open. It was, and nothing was found in that. He has taken away everything. In spite of that, my lord, how can the wife undergo torture, my lord?
When you are ready to pay 15 lakhs, when you will pay that amount?
Your Honor, if there is something which they agree in writing, Your Honor, Your Honor, I have already undertaken to pay another sum of 2 lakh rupees.
What sum of 2 lakhs? We are talking about 15 lakhs.
Your Honor,
full and
if
final settlement.
yes, Your Honor, if the Your Honor, presently, Your Honor, my difficulty is, Your Honor, on one side, I am ready to pay the complete amount, but they are claiming still crores of jewelries, Your Honor. But that, Your Honor, if my written statement,
I will put it to my client, my lord. Even if the maintenance, some concession is given, I'll put it, my lords. But my client is very clear, my lord. She doesn't want to continue because, and she is considering.
Please understand, I'm asking you. The claim is, one is with regard to
Yes.
this 15 lakhs to be paid for the maintenance of the daughter, a lump sum amount.
Please.
And that's the only claim.
Please.
Remaining other things, she
Yes.
is not pressing on anything.
I'll
The
put-
locker or any other thing.
Please, my lord.
Yes, do you? Yes, Mr.
yes, Your Honor, if this is the condition, I am agreed, Your Honor. But Your Honor, may kindly just peruse page number 19 of my written statement, Your Honor. I beg before Your Honor, page number 19 of my written
Come to
statement.
the court on Thursday.
Your Honor, I have my second year LLB exams, which are going to start in upcoming week, Your Honor. On 16th, they will end. Your Honor, there is a date in the family court on 4th of June. I can produce myself.
If you want to settle the matter, when they are ready, you come up with 15 lakhs DD and they will be sharing this to you. You sign it and we will pass appropriate orders.
Your Honor, I'm totally agreed with that, Your Honor. But again, if the claim of crores of rupees of jewelry, Your Honor, that is why I beg before Your Honor to just peruse one page, Your Honor.
What is happening in the court? And repeatedly they are saying that they are not pressing for it, which I'll record. And again, you are going back to that. They're only on 15 lakhs.
Yes, Your Honor, I am agreed with that amount.
Then come up with the DD or check or whatever it is. It's not a check. Come up with a DD for that amount.
Your Honor, I may be please allowed to deposit the amount in the court account, Your Honor, because Your Honor, if in case because there is an ambiguity in the name and everything, Your Honor, please, I am ready to deposit the amount in the court account, Your Honor. And if the settlement is it goes well and it goes through and the decree is granted, that she's Your Honor, the money would go out from my hand the day I deposit it in the court, Your Honor. So once the compliance from
when will you deposit it?
Your Honor, it will, Your Honor, I need in the month of June or maximum by July, Your Honor, I'll have to make the arrangements. I will do that, Your Honor. I've paid 2.5 lakhs out of that. So the remaining amount, whatever is 12.5 lakhs, which it comes to, Your Honor, I'll do it in the month of by end of June or maximum by July, Your Honor.
This is matter as parted. This is matter as parted on
3rd or 5th of June, Your Honor, I'll be coming to Bangalore for the execution matter, Your Honor, which is posted on 4th of June, Your Honor, in the family court.
matters
So
will
if
not
it-
be posted as per your convenience whenever you come to Bangalore.
I'm
And you are paying
sorry,
the
Your Honor.
money. When are you ready to pay the money? That date will be posted.
Your
And
Honor,
that
for
day you will be signing the joint that memo before the court.
Your Honor,
Yes, I'm ready to pay.
Your Honor, anywhere before the family court execution matter, Your Honor, then it is 4th of June, Your Honor. After 16th, my exams are between 16th to 4th of June, Your Honor. 16th of May to 4th of June, anywhere between that time, Your
Are
Honor.
you going to pay by that
As
time? Are you going to pay that amount, 15 lakhs?
I will, Your Honor, it is 12.5 lakhs, right, Your Honor? It is
What
50.
about
I've
that?
paid 2.5 lakhs.
That figure should be 15. If you are paid 2.5, it would be 12.5.
Yes, Your Honor. I
When
will
is
make arrangements between 15th of May to 4th of June, anywhere where the honorable court is
because the court has
able to accommodate.
submitted that. It is submitted with the land counsel appearing for the petitioner, mother that the several cases are pending between the parties, and it is a case. It's a dispute. It's not regarding the child or GNWC or MC.
No, my submission, let him be present on next statement to sign the compromise petition.
That's what I'm asking. He says he will deposit the
That may
money,
be given,
then he'll come and sign the memo. There can't be any difficulty to you.
No.
I'm asking you, is it arising out of the GNWC proceedings or MC?
Pardon me?
Present
Your Honor.
petition is arising out of GNWC or MC?
Trial court matter, my lord. I can get it advanced and close.
It's a MC matter, Your Honor. It's not about the custody.
The counsel appearing for the wife submits the wife is the wife wants to settle this matter, and she is not even expecting a permanent alimony. And you understand what the court is saying.
Yes,
She
Your
doesn't want any permanent alimony, and an amount of rupees 15 lakhs. She's only asking for an amount of rupees 15 lakhs for the daughter. Land counsel appearing for the husband, the party in person who appeared online submits that he has already paid an amount of rupees 2.5 lakhs, and the remaining 12.5 lakhs he would be depositing before the family court by 5th of June. Yes, Mr. 5th of June.
Yes, sir. Yes, Your
5th of June, and he has no objection to mutually get a divorce, and he is ready to enter into an agreement, file a joint memo, and they will be filing. And if only this amount, and if the wife is not asking for if the wife has no other demands, land counsel for the wife submits that. Except this, the wife has no further demands. In that regard, a joint memo, a compromise memo shall be prepared and sent to the husband. In the meantime, list this matter on 9th of June as part of.
Your Honor, it may kindly be directed for by post, Your Honor, because the attachments do not open, Your Honor, in the email.
What is that?
Your Honor, by post, it may be posted to me, Your Honor, the settlement copy, because
Send it by post. Yes.
Serial
I'm
number
grateful, Your
22.
Honor, obliged.
Serial number.
Hearing 22. Arun Govindraj for petitioner.
Appearing for the respondents. my
Nalai
lord.
Muddappa.
I appear for the petitioner in this case. Let's, can it be taken up tomorrow, my lords?
What is this matter?
Let's, the trial court, my lords, has rejected, my lords, has recalled the order directing the respondent to file affidavit of assets and liabilities.
There is no urgency for this. After vacation, next. Please, my lord. 23.
Cell number 23. Prakash M.
Petition, my lord. The husband writ petition, my lord. The husband writ petition. The respondent filed the application for interim maintenance, my lord. Section 144 class 3 of the maintenance order dated, my lord, 8,000 per month, my lord. 5,000 for wife and 3,000 in the son, my lord. The respondent, my lord, she was working as a private company.
What is your income?
22,000, my lord. The respondent payment. The petitioner is working as the jewelers, my lord. My income was 45,000 per month, my lord.
40?
45.
So what's the difficulty in paying
Lord,
8,000?
the respondent is, she was working in the private company, my lord. The earning, my lord, for 22,000 per month, my lord. I produced the statement account, my lord, page number 24, my lord. Annexure D, my lord.
20?
24, my lord. 22,000 per month, my lord. The salary, my lord. One is but a private limited, my lord. 10/5/2022, my lord, date. Earning, my lord, 22,000 per month.
Where do you get that 22,000? Only we see this 22,000 figure once.
Vice, my lord,
On 10/5/2022, where are we now? Only one entry is there for that.
Then, my lord, page number 28, my lord. And 6/6/2022, my lord, 22,000 per month, my lord. She was working at in IS.
Was it not, was it placed before the trial court?
Yes, my lord.
Was it placed before the trial court?
Yes, ma'am.
What is the finding of the family court
Finding,
on
my
this?
lord, my lord, she was after the my lord.
Please
Kindly
come
find
to-
finding, my lord, for page number 39, my lord.
On the other hand, the advocate for petitioner submit that earlier petition number 1 was going for worker. However, now she has left the job and is having child aged about 2 years and she cannot go to work by leaving the child. Child is 2 years old.
1.5 years, my lord. At the time of the application, my lord.
With your salary, you can
My lord,
pay.
she was age parents, my lord. She was 65 years, my lord. He was parents of the petitioner. Age parents, my lord.
Still-
And I produced the medical certificate also, my lord.
You have
Annexure G
48,000 income,
45, my lord.
45,000 income. What is granted by the court is
Hello.
8,000. It can't be difficult for you to pay. Notice to
Hello,
the
my lord,
respondent.
the respondent, she was working at my lord, the private company, she was earning 22,000 per month, my lord. Just get salary, my lord.
You said 45,000.
22,000, my lord. She was responding, she was working at the private company.
See, that we will see 22,000. Yours is 45,000.
Yes, my lord.
Yes, notice to respondent.
Cell number 24. Venkatesh Prasad R.
Yes. Yes.
Lord, the trial court has ordered for 8,000 as the maintenance, my lord.
What is your salary?
My lord, right now I'm working as a freelancer, my lord. I don't have a permanent job because of the petitioner. That's the.
How much you get?
Presently, I'm getting 15,000 to 18,000 as a freelancer. 15,000 to 18,000. That is what I've declared in the.
18,000.
Yes, my lord. So that's what I've declared in the objection statement as well, my lord. But the assets and liabilities has not been filed, my lord. Without giving an opportunity for me to file the assets and liability, this order has been passed, my lord. And over and above this respondent is suffering from
5,000. It is submitted that without an opportunity for the husband to file the statement of assets and liabilities, the court had granted 8,000. He is doing is working as a freelancer and earning an amount of rupees 15,000, 15,000 to 18,000. Considering the same, they shall be stay of all further proceedings on the condition that the petitioner continue to pay an amount of rupees 5,000 per fifth for every succeeding month, and the arrears from the date
4,000, my lord. 4,000.
From the day for the date arrears at 4,000.
Please.
Arrears at 4,000 from the date of petition till today. shall be paid within a period of 8 weeks. Either of it, the default, the stay stands vacated, hand summons on the counsel appearing for the respondent, and shall file a memo to that effect. Yes,
Public.
next.
Cell number 25.
Yes.
Kumar.
My lord, husband filed application for visiting the child, my lord. Child is aged 7 years, my lord. Child is in Delhi, my lord. Husband is also staying in Delhi, my lord. Wife is staying in Bangalore. Lordship, may kindly see page number 22, my lord.
The son is staying in Bangalore, Delhi with whom?
With the wife's parents, my lord.
Maternal grandparents.
Yes, my lord. My
What
only
is the order?
My lord, directed wife to keep the child during mediation, my lord. Though there is a direction, she has not kept the child. I had informed regarding the order, and I have also booked the flight. I have produced the flight ticket also, my lord. I came down to Bangalore to visit the child, my lord. She has not kept the child present. Even next mediation also, she failed to keep the child present.
I'm not able to understand. Come to the order review.
My lord, 22, my lord, which says, my lord, the respondent wife side submitted that she along with their child will visit Delhi in the summer vacation. Now the respondent is directed to keep present the child at the time of mediation and also allow the petitioner spend some time with the child when they are in Delhi. Yet, though there is a direction, my lord, the wife is not allowing to meet the child. Therefore, I had filed an application for further direction and initiation of contempt. It was not entertained, my lord. Therefore, I am before this.
Notice to respondent.
My lord, interim during vacation, my lord, I may be permitted.
Already there is an order.
My lord,
No
there is
further
order.
orders are required.
Despite order, my lord, there is she has not allowed. My limit seeking for a limited indulgence.
Understand. What is this order? There is an order in your favor.
True, my lord.
No, it has to be again affirmed by the High Court.
My prayer is for modification of the order, that interim order is I may be permitted to visit a child at Delhi, my lord. Specific order. Delhi during vacation on Saturday or Sunday.
That's not the way the court works. Yes. Next.
Cell number 26
Notice.
for admission matters. 26 Pradeep B.
Yes, Mr. Pradeep.
26, transfer petition.
26 not list, second list, I think, first list.
Yes.
Challenging the quantum of compensation, notice to R2, 3 and 4 may kindly discuss the deposit 50% for MS.
The memo is filed seeking dispensation of notice to
2 to 4.
seeking a dispensation of notice to 2 to 4. Say memo is taken on record and notice is dispensed with. Issue notice to respondent number 1. It is submitted that the insurance company is on the question of quantum. They shall be stay of all further proceedings on the condition that shall deposit 50% of the amount, and on such deposit, the claimant is at liberty to withdraw.
Before MSCT.
Which is subject to the result of the writ petition. Yes, next.
Cell number 27.
This case, challenging the liability, passenger carrying the goods vehicle.
Challenging the liability.
Passenger carrying the goods vehicle.
In this, they shall be submitted that the claimants are traveling in a goods vehicle and they are as gratuitous passengers, they are not entitled for compensation. Hence, they shall be stay of all further proceedings on the condition that they shall deposit 50% 8 weeks. Next, 28. In this, no order for withdrawal. Yes, third 28.
Notice to
My lord, appeal by the insurance company, my lord, challenging negligence and quantum. My lord, fracture of both bones of right leg and humerus, my lord, 17 lakh and add is awarded, my lord. I am ready to deposit 50% of the award.
Negligence 50% 8 weeks on furnishing security. Half of the amount to be withdrawn. Yes, next 29.
My lord, this appeal is by the HDFC Ergo General Insurance Company. Petition under section 164 of MV Act. My lord, it is a self-accident and it is only a third-party liability insurance is there. The rider of the motorcycle is not covered under the policy. Without considering this aspect, tribunal has fixed the end liability. There is no liability at all.
The policy is a third-party insurance policy.
And also petition is filed after 1 year.
And still the insurance company is made liable. Hence, the insurance company is before this court and appeal. Considering the submission, they shall be stay of all for these proceedings. On the same 50% deposit, 8 weeks, no order for withdrawal. Yes,
Much
next.
obliged.
30 Irimalaya.
Appellant may not claim it appeal for enhancement of company.
Notice. Which is insurance company?
HDFC General Insurance Company.
I will take notice, my lord.
Court will order notice. You cannot
Please.
take.
I am filing the memo for dispensation of notice to R2 and 3.
1 minute. Mr. Ravi S. Samprati is directed to take notice on behalf of the insurance company. You are not appearing. Pradeep, you are appearing. So Pradeep is directed to take notice on behalf of the insurance company. What is the memo for?
Dispensation of notice to R2 and 3.
So a memo is filed seeking dispensation of notice to R2 and R3. Dispense with at the risk of apparent any delay? No delay. Admit course of
No
conduct.
delay, no delay.
Call for the DCR. Registry is directed in the name of Mr. Pradeep. Appeal papers has to be served on him.
Case number 31, preliminary hearing.
I don't think the settlement is happening. If this matter has to be heard by your lordship, may I request for a date after vacation considering that, or if it has to be
My lords, in fact,
released from parted, I'm okay
Please.
for it.
I'll release it from
my
part.
lords, in
I'm
fact,
okay with both, my lords.
we are as well all right with both, my lords, because your lords have spent a lot of time on this. We do not deny
They're
that.
not understanding, but they will
My
understand.
lords, what
it at-
amazes,
No, they will understand it after some time, when the remaining life of
That's
theirs
right.
is around the
Absolutely.
courts, let them enjoy it.
My lords, the only
We can't give any,
clause was the
they should have that
remarriage.
custom.
I think they were able to come down to other clauses.
My lords, they went back on every time, several
only the
clauses. In
remarriage
spite of that, I managed to convince her, and they're sticking on to that remarriage clause even after agreeing that they will take it back. Not once, my lords, that the father was able to.
Whoever is not understanding will face a consequence.
Correct.
Court can't help it.
In fact, by this time, by today, my lords, the settlement, the 1 crore was supposed to be given, and we were supposed to file the joint memo, in fact. And yeah, I'm gratefully, I think I'm grateful for the efforts taken by this court as well as the councils, no doubt at all. But then it's beyond this thing, so.
Lordship, in fact, we have been told that we would leave it to this honorable court's discretion, because all of this was discussed, and the lordship also felt that 50% is fair. Why are they so hell-bent on taking that out? Because if they say they're not going to get married, then it doesn't matter. If they are, then both of them share custody. I don't see what the problem is. And for that, if they don't want to proceed, all along I have noticed that for some reason or the other, the lady doesn't want to proceed signing. So I think that's an indication. But as of now, we would leave it to your lordship, in fact, entirely to decide, your lordship. If your lordship insists that even that should not be, we will not. But the point is, your lordship, for example, last week, he never met with the father. She's not allowed. He just says that get me IPL tickets, I'll come with you. He says, of course. Then he says, you have to take my mother also with me. He says, no problem. So he's willing to concede everywhere.
Because neither the courts can monitor it or anybody can stop it. No, even after spending or,
So
there is no
much of-
assurance for whatever amount. It is
Correct.
just you have to believe. And with all that belief one has to go. The boy may come, may not come. That's the situation.
That's
It's like your client is taking a chance. Nobody can ensure him that it's going to happen this way.
True.
In fact, both, it was like an entire family in the IPL match.
Because now the boy is now 11 years old or 12 years old.
12 years.
So the more like he's growing and he'll have all his more demands, and he has advantage of, either to be with the mother, advantage of being with the father. So he will bargain every time. This will happen. Your client has to convince has to be,
Might I then request your lordship, if your lordship could continue holding on to this matter? Might I, only for this matter, please? And again, during vacation, just similar to the IPL, how they went together as a family, if they're able to work this out during the vacation.
I can assure that.
We can
Beyond,
try something.
off the records, my lords. I can assure that,
can
not
try
at
something.
all an issue.
Lordship, may
But
kindly
the
retain
father
this and-
has to know that somewhere he has to make that effort, because he is a person who is traveling all over the world.
Only the mother also has to understand.
Plus he travels.
She doesn't agree for everything like what my son will say.
No, I do understand.
She will.
Plus
she will
both
be
of
the
them
one,
have to,
she will
yes.
be the one is going to know how many cases are pending, 17 or 18? Or 27?
Must be more than a dozen, my lords.
14.
14 cases.
In fact,
and is it the
my lords,
life worth living like that?
Mila, this almost slipped through when the police started harassing her and she was going to be arrested while settlement talks were on.
As a final opportunity, I list this matter after vacation.
Please.
On that day.
I hope to really bring this to
Something
an
works
end.
out, it's fine.
Definitely,
Please
my
tell
lords.
your clients, court is not interested to waste not even a minute on this case.
On any clauses or anything. We will
Anything.
just work it out.
Definitely.
Whether it is acceptable or not, or else what I do, I will not even pass any orders. I'll delete it from parter and let it go to the.
No, we will want to, we do not, after the amount of time your lordship has spent, we don't want it going wasted, your lordship. We want some,
Same
because we
here.
saw some, spark and the IPL, at least that there is some opportunity for them at least to sit together. It could be possible even through vacation is what we feel, your lordship. There are some more matches left, we can try to get him into that.
Matter after vacation, earlier arrangement with regard to the visitation shall go on.
Please.
There's vacation custody.
During vacation, your
May
lordship,
11th
if,
to 20th.
just 11th to 20th, because other times throughout. she can-
Not overnight continuously. However, whatever your lordship has passed weekend, I will ensure that the child will be sent. It was, my lords,
No. As per the earlier order, the weekend visitation shall continue. As this being the, vacation for the child, what are the times?
11th to
Day.
20th, 11th to 20th, and whenever he doesn't want to stay over, he will drop it. That's all, your lordship.
So 11th.
my lords, I do not know if there are any prior
There
things
isn't,
made.
we verified. We
I
verified.
have not verified, so I'm sure.
We verified, your lordship.
Password. You verified already.
No, we already checked, your lordship.
So 11th to 20th.
I go by them.
11th to 21st, father can exercise the visitation, provided no subject to.
Yeah, the boy.
Not visitation, your lordship, overnight custody. But
Father will
whenever
have
the
the
child
overnight
wants to go
custody.
back, he will.
Father can exercise, no, 1 minute, please listen to the order. The father can exercise the overnight visitation if the boy is comfortable.
Correct.
If the
And
boy-
also if no prior plans are made,
Inviting
because.
an order, if there is a if,
let
he
that
will
not
never
be.
come.
It won't happen. Therefore,
Plus,
your
what is-
lordship, therefore, your lordship may kindly say overnight custody between 11 to 20th years. Whenever the child feels like he wants to go back to the mother, father will ensure that he does.
Plus
drops.
one.
That way, your lordship.
One distinction. Overnight in the family court has not been given. It has been 30% from morning to evening. However, I am not coming in the way if the boy wants to go. In fact, this IPL match also, my lords, she was least interested in going to the match and staying till 11:30. Just so for the father to exercise his visitation rights and so that he can have some time with the child, she went along. In fact, it was a harassment for her because she is not interested in the match. So this was the thing. So that I don't think there should be any embargo, but let it not be 11 to 20th on any 1 week, my lords, when the child is not going out of station, or if there is no plans made, because I have not verified, but I go by them. I have no issues on
Done.
that.
1 week, 11th to 18th, your lordship.
What else?
Please.
That's
So father can have the custody of the child between 11 and 18.
18.
And apart from that, on the weekend custody shall go on.
My lords, if it is second and fourth weekend, yes, that was it. That's all.
Let it go.
That let it go. That's
This is matter after vacation. By the
let a date be fixed, my
This-
lords. Let a date be fixed. Yes.
11th, your lordship.
This is matter after vacation, and by
June
the
11th.
next date of hearing, the parties shall report the compromise, or else the matter will be deleted.
I'm quite confident we'll report
This
the
is
settlement.
matter on 10th of June. Then I have to hear this matter from Dharwad again.
No, my lords, I am quite sure this
We
will
will
be settled.
Oh, right,
Grateful,
deeply.
grateful for you. 10th, right? 10th or 11th?
List as part.
I think she's changing the date. 10th, ala?
Cell number 32. 32, Rupesh Kumar S for petitioner.
Responded in this case. That is confirmed that there is a settlement between the parties. It has been posted before the trial court on 2nd June. It will be called after.
Matter after vacation is submitted to the likelihood of settlement. Next 33.
Cell number 33. Ian.
In this case, my lord,
Only for the respondent.
Archipel directed for the minor to be handed over to us for visitation on the weekend. She was.
It happened.
It happened. It happened very peacefully. There's a check for 1 lakh rupees being handed over.
So this will continue.
Not on every weekend, your lordship.
Uh-huh.
There are few dates with the mother and child will be traveling outstation. I will mention that.
Then,
May 1st and 2nd and May 21 to 28.
no, May
1, 2.
1st and 2nd, she's
Second.
not available.
She's not available. And May 21 to 28.
May 20th to
21 to 28.
21 to 28, she's not available.
No.
Not now. May 1st and 2nd is
Father
Thursday,
to
Friday.
have the registration on 26th. So what we do is, for the boy, what's the age of the boy or girl?
Girl child
11.
11.
11. And what are the activities she's having?
She's having swimming class, taekwondo, and cycling.
You have taken.
Yeah.
her
Yes,
to
yes.
This weekend, the father had taken the child.
Last occasion.
Yes.
So what we do is, now, the remaining days, the mother continues to work.
Yes.
So, like, throughout the vacation, like, 3 or 4 days a week, we'll grant the day visitation to the father. So that when she's not at home,
Please.
mother is not at home in the night, right?
Yes,
In the
madam.
night.
Then we'll grant this visitation from the evening to the father till she comes, till 10 o'clock.
Please, Lordship.
Find out, we'll pass out this matter. What we'll be doing is, on those days, we'll not grant visitation. Remaining days, evening, the mother goes at 2 o'clock
Yes, madam.
to the
Yes.
office.
Yes.
So from 2 o'clock to 10 o'clock,
She returns after midnight. Madam. She returns after midnight.
anyhow, it's okay. 10 o'clock, father will drop her at the place.
Please.
So this 2 to 10 will go on throughout all the days in the vacation, except the days when she is not in Bangalore.
Yeah.
Please
I'll take
get
instruction from the client, Your Lordship.
Pass over. Yes, 34.
Cell number 34, Pradeep B.
Hearing for the appellant in this instance.
Why is it final hearing now?
At last occasion, we had heard sometime.
Hmm.
The deceased was aged was 74 years. 50% personal expenses has to be deducted.
No,
Would
but
be
he has no why.
no, my lord. 56-year-old son and 50-year son.
Sons of the deceased have filed the compensation. Sons of the deceased person have filed the compensation.
He's a disabled person.
Yes, my lord.
Not disabled.
Sons of
Not disabled person.
deceased person, son of the deceased my lord. They have filed this
Correct.
petition for the
Now,
trial court.
for dependency,
Yes, ma'am.
definitely you cannot call a 56-year-old a dependent on a 75-year-old.
Yes.
So we have to, though we are granting loss of dependency, but we will deduct 50%. If 50% is deducted, the amount will drastically come to half.
1,50,000 reduction. Reduction of 1,50,000.
So, what is the income? Which year is the accident?
15,000 rightly taken.
Rightly
50,000 they
taken.
have taken 50,000.
So 15,000,
1/4 is the
half has to be deducted.
7,500
7,500.
into 12 into 5.
How much?
4,50,000.
4 lakh?
50,000.
And conventional
1,10,000 rest of the heirs are rightly granted. 1,10,000.
1 lakh,
80,000 plus 30,000.
88,000. 88,000 plus 36,000. It comes to?
Please.
4,50,000 plus 88,000 plus 36,000.
5,74,000.
What was granted?
7,10,000.
7,10,000. Yes, we'll pass on.
Please.
The agreed with the orders about passed in MBC number 719 of 2021 dated 21/10/20 dated 3rd June 2023. The insurance company is before this court. The deceased was aged about 78 years.
74 years.
74 years, and the claimants are a son aged 56 years and other son aged 50 years. The tribunal had taken the income at 15,000 and deducted 1/3 towards the personal expenses and granted the compensation of an amount of rupees 7,10,000. Aggrieved thereby in insurance companies before this court. Then counsel appearing for the insurance company submits that the children who are aged 56 years and 50 years cannot be considered as dependents of the deceased, and the court ought to have deducted 50%. But in this case, 1/4 is 1/3.
1/3 is
1/3 is deducted. Then counsel appearing for the respondent claimant submits that the court had rightly considered and granted the compensation, no interference is called for. Next, having heard so and so, there is a material on record. The tribunal ought not to have deducted 1/3 and ought not to have considered the sons who are aged 56 and 50 as dependents. In that case, 50% needs to be deducted towards his personal expenses. Then it comes to the court had rightly taken 15,000. It comes to 7,500 into 12 into 5 is 4,50,000. For the two claimants towards consortium or 88,000, the funeral expenses 36,000. It comes to 5,74,000. Accordingly, the appeal of the insurance company is partly allowed, reducing the compensation from 7,10,000 to 5,74,000. If any amount, any extra amount is deposited, they are at liberty to withdraw. If any amount is to be deposited, same, like the other conditions, the amount in deposit shall be forthwith transferred. Yes, next.
Number 1. List number 2, serial number 1, Syed Akbar Pasha for appellant.
Yes, Mr.
Calculation was done last date of hearing.
Give the file.
They have not appeared on that.
We will pass orders. What was the amount granted?
At 8,80,207.
Mm.
The date of accident is in 2000.
It's a case of death or injury.
It's a case of injury, Milad. 90% disability was taken. 90% disability was taken.
So from 8,80,000, it is enhanced to 19,71,000.
Please.
What is the occupation?
Coolie.
Court had taken the income at?
Before the tribunal, Milad, 3,000. 4,000 is taken.
4,000 is taken. Accident is of the year?
2014.
2014. Agreed with the award passed in. Liabilities on insurance company.
Please.
Agreed with the award passed in MSC number 1246 of 2020. 10 July 2019, the claimant is before this court seeking enhancement of the compensation. The claimant had filed the claim petition seeking compensation for the injuries sustained by him in the accident. The tribunal had awarded the compensation as per the table given below at page 23. Though this matter was listed and heard on the last occasion, there was this matter was listed on the last occasion. This court had heard the learned counsel for the insurance company, and there was no representation on behalf of the claimant. And the matter is directed to be listed under the caption parted. Today also there is no representation, and this court is proceeding with the matter on the merits of the same. The claimant had sustained how many injuries? 5 injuries. 5 injuries under the head of pain and suffering. This court is granting an amount of rupees 1 lakh. Coming to the medical expenses, court had rightly considered and granted the amount, and no interference is called for. The claimant was in hospital for 57 days.
Okay.
57 days, and this court had granted, and under the head of food diet, this court is granting 60,000. Coming to the loss of income during the later period, this accident has taken place in the year 2011, and this court is taking 6,500 as income, and for 6 months 39,000. Coming to the loss of future income, the disability is, as per the doctor, 90%.
90%.
Even that was taken by the tribe.
Taken by the tribe.
Is at 90%, but no future prospects were granted. So taking the salary into as 6,500 plus 40% future prospects would come to 2,600. That is 9,100 into 12 into 16 into 9,500 is 15,72,480. Considering the disability of 90% towards loss of amenities, this court is granting 60,000. Towards future medical expenses, no amount is granted, and this court is granting an amount of rupees 50,000. And towards legal expenses, 10,000. In the light of so and so, altogether the claimant is entitled for an amount of rupees 19,81,487. Accordingly, the appeal is partly allowed, enhancing the compensation from 8,80,207 to so and so.
Serial number 2, read by HR for appellant Pallava R.
Yes.
There's something else.
For a respondent.
My lord, I have to argue, my lord, on the loss of future earnings, my lord. What I did not bring to your lordship's notice is, my lord, in the wound certificate, the injury, my lord, fractured to metatarsal bone is not mentioned. The doctor says in his evidence that he has suffered a fracture of metatarsal. To show that, my lord, the treatment taken for metatarsal bone, my lord, nothing is produced except a clinical note and the evidence of the doctor. There's nothing produced. Now 12% disability is, and added to that, my lord, he says that he was an advocate and he admits in the cross-examination that he has not produced the enrollment certificate, and he also adds that he's doing agriculture. To show that, my lord, he is an advocate, he has not produced. Then, my lord, the 12% disability, my lord, is given because there is variance in the wound certificate and the evidence of the doctor, my lord. Therefore, the taking 12%, my lord, would be on the higher side. Therefore, my lord, your lordship could, my lord, consider the enhancement, my lord, on other heads, my lord. Instead of instead of loss of future earnings, my lord. Pain and suffering 20,000 is granted, my lord.
We are granting 40,000.
Yes, ma'am.
Loss of amenities 30,000.
Yes.
Food nourishment, he was there in hospital 5,000.
Yes, ma'am.
Then loss of income during the later period 13 to 3, 39,000.
And medical bills, my lord. I just
Loss
passed.
of amenities.
My lord, medical bills, I have a submission on this. My lord, 37,000 is claimed by a surgeon. On a white sheet, my lord, he gives the, it's not even on the letterhead of the hospital, my lord. Can I just pass on? I have the, that is exhibit, the part of the exhibit, my lord. This is doctor's cash certificate. Can I pass on, my lord? For 37,000, it's on a plain paper typed, my lord. It says surgery, but it's not supported by the documents.
Discharge bill 16,300.
65,100 is awarded towards medical bills, my lord.
Medical bills are there.
That's what, my lord. This 37,000 is included in the medical bills, and the one which my lord, I requesting your lordship to have a look, my lord. It's on a plain sheet. The surgeon gives, my lord, his bill. And none of the hospital records are produced, my lord, except medical bill and prescription number. And one more thing, my lord, one more aspect is, my lord, the witness PW2, my lord, produces exhibit P11 clinical notes, my lord, P11, my lord, which is dated 2010-2021. Accident is of the year 2018, my lord. Therefore, my lord, the entire, I have challenged mainly, my lord, on loss of future earnings.
My lord, on record advocate is not available, my lord. And also, my lord, there is
Delete this matter from Parker. This is matter after vacation.
Bill number 3. Madhu MT. Petitioner.
This matter was listed before the court on 9/4/2025. As there is no representation, the matter is directed to be listed today on the caption for dismissal. Today also there is no representation. Accordingly, dismissal non-prosecution.
Bill number
Next
4.
3. 4.
I appear for the petitioner rights in this matter. I appear for the petitioner in this matter. So we have filed this transfer petition. Wife has filed this transfer petition, my lords.
Who is the counsel?
I appear for the petitioner, Colin Priyanka, my lords.
Yes, as per the order passed for this court.
Yes, ma'am.
The council had served the hand summons and filed a memo to that effect. It is submitted that the notice is served on who is the counsel?
Counsel name.
Myself for the petitioner.
Trial court.
Trial court, yes.
Ask her to write on this memo and call it in absence at 2:30. Yes, next. In both the cases, next case also. 5.
Cell number
Some of
5.
the petitions are taken process to the second
Cell number
respondent.
5.
I've already taken process to the second respondent, my lords.
Oh,
The
it is
correct
submitted
address.
that the needful is done. Just after service of notice. Next 6.
Cell number 6.
In all these cases, if stay is there on the last occasion.
Number 6, my lord, sir. And for the petitioner, matter has been amicably settled.
Take that.
Cell number 6.
Take that. It is submitted that the parties have settled the dispute amicably, and in that view of the matter, this petition becomes infructuous, and a memo is filed to withdraw, or what did you say? To dismiss it as infructuous.
Dismiss.
Dismissed. Yes, next.
It's
Seven.
not
Number
serial
7.
5 interim order may be kindly.
That's what I already said even before you asked. Yes, 7.
Cell number 7.
This matter has already take steps today, my lord. Steps taken, my lord, today.
It is submitted that the needful is done. Just after service of notice. 8.
Cell number 8.
So before the petitioner in this matter, already served a copy at the registry, my lord, that having served the respondent's counsel. Process has also been taken out, my lord.
Where is the hand summons to which advocate? What is his name?
My lord, I filed a separate memo dated 23/4/2025.
Advocate.
Name of the, he is,
Give it to him. Let him write on that.
yes, please, my lord. JRA advocate. It's written on the JRA advocate. On the copy of the hand summons, JRA
He should have a name.
is written his initials.
You should have. That's why I'm specifically asking the advocates to write it in the hand, the memo, saying that as per the order, hand summons are served on the counsel, Mr. So and so.
Yes, please add.
That is not the. That can't be the name. You have to verify.
No, no, I'll verify now.
Password.
Yes, please.
9.
Cell number 9. From IAVP.
The office objection is, I have filed an IA for dispensation, production of certified copy of annexure B1. That is
What is
not,
B1?
my lord, is entire order sheet of the trial court, my lord, I have taken printout from the website of this honorable court. My lord, I have produced the certified copy at annexure B. The certified copy is up to, at page number 18, my lord will get. Certified copy will be up to 26/3/2025. Bottom, my lord, page number 18. It is up to 26/3/2020.
Typed copy. 18 is typed copy.
Certified copy is at page number 17. That is what type. It is up to 26/3/2025. With this petition was filed on 25/4/2025. That's why, my lord, I have taken printout of the website from the this honorable court at annexure B1, page number 19. Up to date order sheet I have produced at page number 20. I am filing a memo to drop the office objection, my lord. Filing memo giving explanation for filing such copies. May kindly be taken, office objection may kindly be overruled.
That should have been filed before the registry.
Registry, I have filed the IA. I have filed the IA. Registry.
Raised any objections?
Yes.
You will send all this before the registry. If the registry is not happy, it will be placed before the court, isn't it?
My lord, the matter is posted on 3/5 for argument. That is the urgency, my lord. Otherwise, we could have complied in the registry. They will not file. Give time to comply the office objection. It is only one submission, my lord. That is nothing more than that. Since certified copy of annexure B is produced, why you have produced?
Objections, the office objections, or yes, what is this matter about?
My lord, petitioner is seeking transfer of the diverse petition from Mandya to Davanagere city. My lord, distance is under.
What is the stage of the case in MC?
My lord, now it is posted for argument. It was filed on October, my lord, October 2024. We have appeared and sought for a time to file objection that has been rejected. And it is posted for argument on 3/5. We have not yet filed objection, my lord.
When is the MC filed?
My lord, it is 6 at page number 20, 16/10/2024.
16/12?
10/2024.
And now in 25 is for arguments.
It is posted for argument, my lord, at page number.
MC is filed by the respondent seeking divorce.
Restitution of conjugal rights.
Restitution of conjugal rights on 16/10/2024. And the petition has appeared before the court and sought for time. It is submitted that the MC is filed on the file of the principal senior citizen and CJM at Mandya, and the claimant and the petitioner wife is residing at
Davangere and she is having a small kid aging 8 years.
And she has to take care of the child who is aged 8 years, and the distance,
710 kilometers.
305, sir.
305 kilometers, sir.
the distance is 305 kilometers.
Up and down 710
They shall be
kilometers.
free of all further proceedings. Say, hand summons and, yes, next.
My lord, for handover of the order, my lord. Third, it is cases posted.
You can wait from September, from December, and last minute you have to come and court has to give a hand summons.
My lord, this is under different circumstances, my lord, not otherwise.
And delivery of the order.
Please.
Oh, all of you have to understand the difficulty of the courts also. Just like that, you can't.
Yes, please.
Yes.
Cell number 10.
Yes.
Ananda K.
There is a letter, my lordship. We have to go through that letter, my lordship. Kindly have it an after vacation.
Refer to the hospital, for urological assessment.
You want a copy of it? The registry is directed to issue the copy of the report from the National Institute of Mental Health and Neurosciences. This is matter after vacation. Next 11.
Number 11.
My lord has already dictated the judgment. Only for dispensation of notice to R1, my lord, I filed an memo for dispensation of notice.
Dispense with at the risk of appellant. Where is the calculation?
Regarding that pay and recovery order.
Huh?
Only pay and recovery, the shifting of liability.
Yes. The appeal is filed by the claimant, agreed by the order of the tribunal, whereby the liability is fixed on the owner of the vehicle, and the insurance company is exonerated from the liability. When counsel appearing for the insurance company or the claimant submits that the tribunal had fixed a liability on the owner of the vehicle on the ground that there is no permit as on the date of the accident. He had relied on the judgment of the Honorable Appellate Court on Rani versus so-and-so, and Amritpal Singh, and submits that still the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. The counsel preparing for the insurance company submits the court had rightly considered and passed the order. Having got the counsel in the side, there's nothing more. The only ground on which the insurance company is exonerated from the liability is that the vehicle was not having a valid permit to fly at the place where the accident had occurred. In the light of the law laid down in so-and-so, still the insurance company is liable, and accordingly appeal is partly allowed, applying the principle of pay and recover. Yes. Next.
Contributing negligence 80% has to be covered. 80% has to be.
Remaining things, we are not only on that point.
Cell number 12. Syed Abdul Sabut.
Yes.
For furnishing of.
Give that. Who appears for the respondent list?
Division and control of case.
KSRTC. Mysore. HR Renika is directed to take notice on behalf of the respondent insurance company, the respondent KSRTC, and the counsel for the appellant shall serve the copy of the appeal memo on the counsel. This is matter. Call for the DCR, admit, post of final hearing. Next 14.
Cell number
Memo
13.
for acceptance of paper publication, acceptance notice to R5 is sufficient. Yes, 15.
Cell number 15.
I appear for the petition.
Admit, post for final hearing. Please, yeah.
My lords, 15, I have already.
No, not 14. It is on 14, 15.
Yes.
15.
No, 15.
No, that order is in 14, I'm saying. Yes, 15.
My lords, in 15, paper publication has already been taken, my lords, as per the directions of the court. So since there is no contest, petition may kindly be allowed for letters of administration.
No, we have to look at it, it is still. After vacation, we'll.
My lords, if it could be because there is a aspect of shares in the foreign company and it's a widow, my lords. It could be on.
Again, we have no time for all that. It's the same.
My lords, the notice to the DC may be dispensed with.
Accepted, no?
Notice to the DC may be dispensed with. I filed the IA.
Yes, IA for dispensation notice to the registrar. What is the amount paid?
No, I have only paid the basic court fee. On grant of letters of administration, the full court fee of 39,000, I am ready to pay.
Not that. For the valuation of the same, we issue notice to the deputy.
No, Malaz, the question
Not
of,
the registrar.
Malaz, the question of notice comes only if I'm not, only for the valuation. I'm ready to pay the full court fee.
That's what you can pay.
Generally, it is done after grant of letters of administration. Otherwise, I leave it to the court. I'm ready to.
No, the whole purpose of this, no, the other day I've seen some order. No, in view of the amendment, either it is one maximum is 35,000.
39, my lord.
39,000.
That's all.
If 39,000 is the maximum amount is paid,
Yes.
question of notice to the deputy registrar will not arise.
I've undertaken that, my lords, saying that I'll pay the court fee on grant of letters of administration.
The IA number 1 of 25 is filed, seeking dispensation of notice to deputy commissioner. It is submitted that the petitioner is ready to pay an amount of the amount of 39,000.
On paragraph 10, I've said the
39,000.
relevant court fee as applicable herein is paid. The petitioner undertakes to pay the court fee on grant of the letters of administration.
On 39,000, the grant of letters of administration. Hence, notice to deputy commissioner is dispensed.
Obliged.
Yes, next 16.
Malords, may I request a date immediately after vacation?
List is matter on 17th of June. Yes, 16.
Serial number 16.
And for the respondent,
Please.
Why MFA Oriental Insurance Company, no counsel's name?
They have already deposited the amount.
That
That
is
is in
true.
FD.
When an appeal is filed, where is why the
The
deputy's
appeal
name
has
is-
already been disposed of. I mean, FD is here.
Oh, the amount in deposit was not directed to be.
No, it was directed to be deposited in FD for a period of 2 years. Already both the FDs are matured with regard to respondent number 1 and 2. That may kindly be released and directly credited to the bank accounts of both.
Where is that order? Where do you get that?
The order dated 28/9/2015.
27th April 2015 is the order.
28 September 2015 and 7/7/2017.
Please show the order which is referring.
Subsequent.
Of 127. How many times these matters will come? The order of the commissioner to discuss some more rupees has been ordered to be withdrawn. So and so is ordered to be invested in fixed deposit. So and so has been ordered to be deposited. So and so with respect to the other two respondents. So and so is paid that the amount payable to first respondent may order to be issued in the name of the bank. The office is directed to issue checks for some more rupees. Amount is deposited where before this court?
Yes, yes. That means respondent number 2 was a minor. Last year only became a major.
Generally, whenever there is an order, the amount will be directed to be transferred to the trial court. All these applications would generally be filed there.
But the amount is in deposit before this honorable court.
I want to see the first order, not 28/9 order.
Two orders are there. I already given.
Where is the first order pertaining to the deposit?
I given two of both the orders.
What you have given is 28/9/2015 order.
Yes.
Where is the second order?
Another order also.
In that it is not there, only one order is there.
I have given both the orders.
When is this order? The IA number 1 of 24 is filed for release of the FD amount. The court had directed directed the amount to be deposited in any nationalized bank for a period of 2 years. The further the amount ordered to be kept in fixed deposit in the name of Srimati, Bindumati and Master Akash shall be for a period of 2 years. Now the application is filed stating that the IA2 of 24, IA number 1 of 24 is filed for release of the FD amount in respect of R1. IA number 2 of 24 is filed for the release of amount in respect of R2 as as per the order passed by the court. Now the 2 years period is elapsed. The claimants are at liberty to withdraw the amount deposited in the fixed deposit.
One number, the amount may kindly be directly credited. I have given the bank details also by way of electronic transfer. That means with regard to respondent number 2, he needs the amount to pay the college fees.
No, by getting all those details and all, before the registry, you should take by get on production of the ID cards and other.
I have already.
The registry shall release some. Yes, yes, on proper identification. Yes, 17.
Cell number 17.
Much.
Raghu R.
I have completed the all office.
Recall order.
I have completed the all office submission as per the Sama court, my lord, in last.
What is this recalling of the order?
TNP dismissed for non-prosecution, my lord. Filed in office submission, my lord. I have completed the all office submission yesterday.
That you have. Now, why should we recall the order? Why should we condone the delay?
My lord, he is having 75% of disability, my lord. Petitioner.
Then why the case was not pursued?
My lord, kindly see my affidavit, para number 5 of the. It may be delay, may be condoned. Interest may be denied.
Anyhow, that without you asking for it, the court will do. But why? What were you doing when an order is passed?
Yes, ma'am.
And whenever you realize it, you will come. Has been filed against him, so assistance and legal compensation. From 2019 to 2025, 6 long years. Is it right to condone this delay and again give you an opportunity?
Because he is having a very much disability, 75% having.
I can understand. 6 years, you will not realize that what is happening to your matter.
Apologies to Sama court. Apologies to Sama court.
Notice is also not ordered.
In office submission, it is dismissed.
Which is the insurance company?
Tata agent.
Mr. Janardhan Reddy is directed to take notice on behalf of the respondent insurance company. Let's just matter after vacation. After vacation, we'll see. Yes. Then council should serve the copy of the appeal memo on the council. Then what about liabilities on whom?
Liability on the insurance company, my lord.
Then you have filed
Yes, my lord.
where is that?
I will give the memo. And
A memo is filed seeking dispensation of notice to
R1, my lord.
R1. Accordingly, memo is taken. And notice to R1 is dispensed with. Tell Mr. Give the papers to Mr. Janardhan Reddy. If anything, if it can be disposed of, we will do it.
In the meanwhile, madam, delay may be condoned, interest may be denied.
We will do it at once. Ask him if he is there. We will take it up today itself. Keep this matter passed.
He is done.
Huh?
Today is there. No, he is no, my lord.
Today?
He is not in station, my lord.
He's not there. Yes, post after vacation. Yes, next. IA to be kept pending. Everything.
Serial number 18 adjourned, serial number 19.
Serial number 8, I've given the name of the council, my lord.
So and so as per the order passed with, in which case?
Serial number 8.
Serial number 8.
8 is passed.
He's saying the advocate's name or something.
Jagannath
Serial
P.
number 8,
Agnihotri.
The advocate, it is submitted as per the hand summons. They have served the notice on so and so. Bring the name of the advocate, list is marked after vacation.
The interim order may kindly be extended.
Interim order earlier granted is extended. Next.
Highly grateful.
That in serial number 18 also interim order may kindly be extended.
Interim order 18. When is this matter?
My lord, morning some other side has taken time.
Look at it, 18. If it is interim order, it has to be extended. Yes, 19.
My lords, I am for the petitioner. 19. My lords, the senior met with an accident yesterday. My lords, he had a fracture. Great segment.
Let's see after vacation. What is the CP interim? What is interim right?
My lord, unnecessary drug and the proceedings said that they already filed a
Transfer
G&W
petition. In a transfer petition, court will grant interim custody.
Already the sample court granted the interim custody and the writ petition, my lord.
So it will be done in the CP also. Yes, after vacation.
Great. Number 20.
No reply.
Nandan.
Petitioner ownership. Wife's petition seeking transfer of the MC petition filed by the husband in the.
Who moved the memo?
I didn't move.
No, you have the stay
I have this.
after vacation. No representation for the respondent. Next.
Your lordship, interim order may continue. Interim order may continue.
Interim order earlier granted is extended. Next.
Serial number 21 adjourned, serial number 22.
I appear for the petitioner, my lord. It is a wife petition for transfer from Assam to Bangalore.
Yes, what is your objection?
Included they are not filed affidavit.
Morning they sought for some health reasons, they said so. And they said they have informed you also that I have recorded.
21 adjourned.
Yes.
22.
I appear for the petitioner, my lord, in this case. It is a wife petition for transfer of petition from
You
Assam
have
to
a stay? You have a stay?
Yes, my lord, I have a stay, my lord.
Yes, no representation for the respondent. Post after vacation. Yes, next, 23.
Extended, my lord.
Wife's petition for transfer of divorce petition filed by the husband from Bangalore.
I am for the respondent in this case, my lord. The respondent residing in Dubai. I filed the memo of appearance to acceptance.
It's
What
contested.
is this, ma'am? She has to send a notarized one.
Yes, ma'am. I will next date of hearing.
Huh?
I will file next date of hearing.
It is submitted that the respondent is staying in Dubai and it gets the affidavit notarized and filed by the next date of hearing. Stays there.
Please.
Post after vacation.
Interim order may kindly be extended. I'm obliged.
Yes, 24.
Serial number 24.
Is a wife petition, my lords,
Manjuna.
seeking transfer MC
Kashina
petition
Devi.
from Bangalore to Mandya, my lords.
MCs of which year?
MC of the year 2023, my lords.
Then what is the present state?
Filing of statement of objections to the main petition, my lords.
Where is that? Where do you get that?
Here filed page number 29, my lords. 29.
Petition present. Objection to main petition.
It is again posted.
Present petition is filed seeking transfer of MC number 1742 of 2023 pending on the file of the second edition. Principal Judge Family Court Bangalore to the Jurisdiction Family Court Mandya. It is submitted that the claim petitioner is a resident of Mandya and it's difficult for her.
Restitution has been filed by the wife,
the
my lords.
restitution at
It is
Mandya.
pending in Mandya.
Difficult for her to travel. Considering the same, there shall be stay of all further proceedings, hand summons and all. For this, give the dates in August.
Obliged, my lords.
Serial number 25.
Yes.
Petitioner, the one Jayashree, it is the daughter-in-law of the petitioner herein, has filed a claim petition, my lord, in MEC number 1490 of 23 at Mangalore, my lord. During the pendency of the petition, she was died. My lord, the petitioner herein are the parents-in-law of the said deceased Jayashree Malada seeking transfer from Mangalore to Asan.
How can it be? Why should it be transferred? Why should it be transferred?
Malada, the first petitioner, Malada, aged about 67 years and suffering from 75% to disability by birth, Malada. And second petitioner, Malada, is the wife of the first petitioner, Malada.
Let's see the notice. Who appears for the respondent?
Respondent, Malada,
ICICI Lombard.
Lamar, Malada.
Who is there? Who is appearing?
B. Pradeep, Malada.
You are appearing.
Okay, please.
Mr. So and so takes notice on behalf of the respondent insurance company. Issue notice to respondents 1 and 2.
Only one. One.
Respondent 1. Issue notice to the other respondents. List this matter immediately after vacation on 4th of June, and the petition shall serve the copy of the petition on the counsel for the respondents. Anyone know the? It's already a.
Sat for stay. Sat for stay, Malada. Malada.
No. Vacation is approaching, and immediately after vacation I have posted. That time they'll get instructions what is the stage and what is happening there. We can't state right now. Yes, 26.
Till number 26.
Transfer petition filed by the wife, Lordship, seeking the transfer MC petition filed by the husband from Shivamogga to Bangalore.
Distance
is 305. 500
Here is the MC.
2024. And meanwhile, before that, we have filed the maintenance.
What is the stage of the MC?
MC is appearance of the party before the.
This is seeking transfer of MC number 55/2024, filed by the husband seeking restitution of the conjugal rights from the senior civil judge at JMFC Shikaripura, Shivamogga to the principal judge family court at Bangalore. It is submitted. The wife is residing at Bangalore, and the distance is 305 kilometers. Stay summons also.
Stay.
Yes, 27.
Till number 27.
Seeking transfer, my lords, from Mysore to Davangere.
Which year is the MC?
MC of 2025, my lords.
Transfer. This is an MC seeking. This CP is seeking transfer of MC number 80 of 2025 from the first edition principal judge family court at Mysore to the family court at Davangere, and it is submitted that the distance is
360 kilometers, my lords.
60 kilometers. There shall be stay of all further proceedings. Same hand summons. Dates in August. Yes,
Till
please.
number 28.
Please.
Yes.
Appearing for petitioner wife. Transfer petition from Chitradurga to Tarikere, the distance of 120 kilometers. And she has to take care of aged parents and disabled brother. 2024.
The CP is filed seeking transfer of MC number 183 of 2024 from the second edition senior civil judge at JMFC Chitradurga to the court of the senior civil judge at JMFC Tarikere. It is submitted. The distance is?
Distance is 120 kilometers.
Is 120 kilometers. Same order. With
May I
regard to
request
hand
for a
summons.
stay of the.
Yes, 29.
Till number 29.
I am appearing for the appellate, my lordship. So kindly consider my IA number 1 for the, that is stay, because the period will over by 27 of
You are the
next
tenant.
month.
You are the tenant.
For the vacating the premises, my lord. Kindly peruse my
When is the date? When you
27 next month. That is during the vacation.
27 May.
Ah.
We'll hear it after vacation.
Kindly
Till we will grant.
One submission I would like to
extend this term.
One submission I would like to make. I cannot file an execution during the vacation. I can file it only after the vacation, and therefore matter may be posted immediately after vacation.
No, or shall I record that without granting any stay? I'll give a particular date.
Yes.
Till such time,
Very well.
till such time, the respondent it is submitted that they'll not take any coercive steps. They'll not. It is submitted by the
Till next date of hearing, kindly extend.
That is what is the.
Okay.
When counsel for the respondent submits that, till the next date of the, it is submitted that till 10th of June.
Earlier, little earlier.
Because there's so many matters after vacation, even for the next bench also.
Don't
we can't
want 10th,
just,
madam.
I will only make one submission. The present petitioner is in possession of the premises for the last 28 years without paying a single 5 years rent.
There is no jury relationship, madam. There is a cloud and ambiguity as to the title of the property, my lordship.
All
Kindly,
that has been
this is civil
considered.
case,
What
my
happened was
kindly revert back to.
and to submit the, yeah, there should be an opportunity to him also.
The father of the petitioner was inducted as a tenant in the year 1994. In 1997, there was an incident. A street, the electric pole fell on the daughter of the tenant, and she died as a result of that. They stopped payment of rent from 1997 onwards, and till today, not a single fine has been paid. And when the petition is filed, they come and say that we have become owners of the property by forging certain documents.
My last.
And all that has been considered by the
Counsel,
law.
I'm not hearing on the merits of it. He's saying something. Let me listen to that. Yes.
My lordship, so there is no single agreement or rent receipt with the, that is owner, my lordship.
Land counsel
So,
appearing for the respondent
is the
submits
case
that
10th
till
paid of-
June 10th,
Can
they
you
will
give on
not,
11th,
they
my
will
lord?
not,
11th coding, my
I'll not grant any stay.
lordship. No,
Grant any stay. If you're not understanding,
I to my lordship, 10th only.
the respondent is not going to take any coercive steps till 10th of June.
Okay.
This is matter on 10th.
Okay.
Yes, next.
Cell number 30, Peter DS.
Yes,
30, Peter DS.
no representation after vacation. Admit post for final hearing, TCR.
Cell number 31, HN Basavaraju.
No representation on behalf of the appellant. List this matter after vacation. 32.
Cell number 32, AN Vishwanath. PC Sitaram Rao.
After vacation.
Cell number 33,
Yes, Mr. Patil.
For the claimant in this case, Your Honor, petition for enhancement.
Yes.
My lord, that date of accident on 18/3/2015.
Case
And,
of injuries.
Injuries, grievous injury.
Please come to the table first. Liability is not in dispute.
No, ma'am.
Liability
No,
not-
not.
So how many are the injuries?
36 years old.
Huh?
36 years old.
No, he's 36 years. What are the injuries sustained by him?
That left leg,
Only one fracture.
one multiple fracture, that is.
Come to that part. For the pain and suffering, we have to see what are the
That's
injuries.
Issue number 2, my lords, paragraph number 11.
Petitioners. Where do you get the injuries?
Laceration over left foot on dorsum aspect extending into medial and lateral aspect of left foot.
Petitioner had sustained injury, laceration of the left foot on dorsum aspect extending into medial and lateral aspect of the left foot.
Of left foot.
The said injury is one injury.
Grievous in nature.
We'll have pain and suffering 40,000. Next, medical expenses as it is.
And my lord, disability, what that tribunal has taken.
We will come to that heading. Please wait. Then, how many days he was in hospital?
6 days, my lord.
6 days.
So rightly granted. 10,000. No, please come to the discussion with regard to the disability. Come to para 14.
S- 17% of the whole body, but tribunal has considered only 7%.
Now, what is the basis for?
Yes, my respectful submission is this, my lords. Lords, he was an account assistant, my lords, in Vijay Lakshmi Agarbatti Works.
No.
Please.
There will be a basis for the court
Yes.
To assess to believe or disbelieve the evidence of
Yes,
the
ma'am.
doctor. So without any basis, just like that, it is not correct, something is correct about it.
And moreover, my lord, that
Kindly see, may I submit? But for these kind of
You cannot supplement the.
yes, ma'am,
reasoning
I
of-
understand.
You can't supplement.
But
And the reasoning that is given by the court is
He is
wrong.
on the higher side because, my lords, you would have, my lords, seen the, my lords, patient is one and, my lords, cross.
That is the case.
Yes.
According to the court, that the proper assessment is not done and the other things.
There
you
is
can
no
understand.
reasoning, my lords, in this, my lords.
So just like he says 17%, let me take.
But may I respectfully submit this, my lords. For the injury, my lords, what he has sustained and, my lords, with the avocation he is carrying on as account assistant, my lord, this disability, my lords, what is taken, my lords, would be just and commensurate to the injuries what he has suffered. Second thing is that, my lords.
What we do is.
Yes.
Coming to 16%. So and so, that is, that's a rounded about 17, that's what the doctor said.
Yes.
We will take 12%.
My respectful submission is this, my lords. If he has continued in the service, my lords,
No,
only
no.
this, my lords.
That is not the finding of the court. If
Yes.
that is your argument, we have to take 17%. If not, we will take 12%.
Please.
Loss of income. Which year is the accident or what is his income?
My lords, it is the
2015.
20,000 is taken, my lords, as his income. Because, my lords, he was working in
the
this
salary
and
slip.
had produced salary slips.
So 20,000 is taken.
Yes, my lords.
So 20,000 into 12, what is the multiplier?
15, my lords.
15 into 12 by
4,32,000 it will work out.
4 lakh.
4,32,000.
Then loss of amenities. 30,000. Loss of income. How much is granted loss of income?
Loss of income during treatment period,
Loss of
40,000 for 2 months it is rightly granted.
loss of income. 40,000. Future medical expenses.
10,000 is granted, my lords.
Another 10,000.
Please.
Legal expenses. It's coming to 6,76,500.
6,65,500.
10,000 you must have not added legal expenses.
Please.
My lord, that exhibit P12 was not considered. That bills which I have been submitted before this tribunal, that the tribunal has not considered.
What are those bills?
Page number that is.
No, if you have to consider all that, then I'll post it after vacation. Or else be happy with this 4
My
lakh.
lord, that is only for bill. That is 50,000 rupees.
If you want, I can.
Exhibit
no
P12.
difficulty in that. But now I can't. Court do not have the time to look at the medical bills also. If you are okay with that, we'll pass order. It is coming, already it is more than 2 lakh 30,000 is the enhancement.
Kindly
The-
be considered.
Agreed with award passed in MEC number 1278 of 2015 dated 18 July 2016. The claimant is before this court. The tribunal had granted the compensation as per the table given below. Land counsel submits that under the head of pain and suffering, loss of amenities and loss of future income, the amount that is granted by the tribunal is not a reasonable compensation. It is submitted that when the doctor had deposed that the disability is 17%, the court had taken the disability at 7% without any basis, and on all the heads, the compensation needs to be enhanced. Then the counsel appearing for the respondent submits that the tribunal had rightly taken 7% as a disability. It is submitted that he is working as an accountant, and the injury and the impact it has on the claimant is occupation, and in in those circumstances, the disability that is assessed at 17% is on the higher side, and court had rightly taken 7%, and no, there are no reasons to enhance the compensation. Next, for having heard the counsels on either side, there is a material on record. Considering one previous injury that is sustained, this court is granting an amount of rupees 40,000 towards medical expenses as granted by the tribunal, that is 94,500, towards conveyance, the transport, attendant, nourishment. Court had granted 10,000, which is a reasonable compensation, and no enhancement is called for. Then coming to the disability, when the doctor has considered the disability at 50% to the whole body and to the limb, to 17% to the whole body and 50% to the limb, the court without any basis had taken 7%. Considering the argument of the land counsel for the insurance company and the occupation and the injury, this court is inclined to take 12% as disability. 20,000 into 12 into 15 into 12 by 100 is 4,32,000. Towards loss of amenities, this court is granting 30,000. Then coming to the loss of income during the later period, court had rightly granted 40,000 and no interference is required. Towards future medical expenses, this court is granting 20,000. In the light of the law laid on in so and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 6,76,500, and the appeal of the claimant is partly allowed, enhancing the compensation from 4,36,500 to 6,76,500. The enhanced amount shall carry 6% interest.
Nice.
Number 34. 34, R.B. Sadasivappa for appellant, Renuka.
Please, ma'am.
On the issue of delay, my lord, and it's covered by the decision, but the date of accident, my lord, is 1/4/2001, my lord, and the date of petition is 25/5/2012. 25/5/2012, my lord, and he was working, my lord,
After these many years,
Yes, ma'am. After 11 years.
you're against the dismissal of the petition.
Yeah, I'm again for enhancement and
My lord,
two appeals. One filed by the.
well, the enhancement would
Your
come,
appeal is considered.
Yes,
Your petition is considered.
consider. Yes, ma'am.
and there's a
It is considered.
Please come to that particular finding. How when for an accident of 2001, 2012 claim petition is considered.
Before that, my lord, only one submission before the court. The previous order of this honorable court on 26/9/2024, there was a direction for them to produce certain things. For example, kindly look into that order.
that's quantum, my lord, on
After
quantum.
hearing the
If your
argument
lordship
on
is
both the sides,
not, my lord, if your lordship is satisfied,
It is necessary for the KSRTC shall file the table containing 3 rows. DC. Column A shall carry the entitlement of the deceased salary for the relevant period from 1/4/2001 to 6/4/2004. Column B shall carry what was the salary that was paid to the employee. So column number C, what is the difference?
We will go to that provided this court wants to adjudicate on the enhancement of compensation.
So
The first hurdle you have to pass is about this delay. 2001, 2012, how can the claim petition be considered? So let us look at the reasoning given by the tribunal. If the court is convinced with that, we'll ask them for those details.
para 9,
Please.
paragraph number 9.
Yes. Please read.
On the other hand, the respondents have denied the petitioner that the petitioner is not maintainable either on law and facts. The petition is filed after a lapse of 11 years, hence it has to be rejected on the ground of delay and laches. Well, this is the ground, my lord. And on 2/4/2011, the petitioner was discharging its duties as a driver in the vehicle bearing number so-and-so, which was proceeding from Bangalore to Madurai. At the check post, a lorry bearing number so-and-so came in the opposite direction and dashed against the bus, resulting in which the driver lost his right leg. Medical advances and IOD were sanctioned to the petitioner. On 25/1/2001, the petitioner had filed the petition seeking for compensation, but it was not in proper format, and there was a delay of 11 years in making the claim. He is still working in KSRTC and has not suffered any loss of income. And we have said that, my lord, he is being given, his pay is protected, my lord, on account of the, and there's no finding, my lord, as regard to the delay is concerned, my lord, that though I have raised this ground, my lord, the court has proceeded to pass the order, my lord, on the merits of the
On
case.
considering the petition arguments along with the written statement filed by respondent, it can be safely said that the respondent does not dispute the fact there was an employee under them as on the date of the accident. Also, it is not in dispute that the injury was caused during the course of his employment in view of the admission made by the respondent. Now, what is your submission on the delay?
No, my submission on the paragraph 9 itself, my lord. Kindly look, okay. On the other hand, they have contention, they have taken a contention that there is not maintainable error of law and fact. After a few lines, on 25/1/2001, the petitioner has filed a petition seeking compensation. So accident is dated 1/4/2001.
After the day, what happened?
No, immediately after 25 days, I have filed my petition itself. But it was not in a proper format. Is given reason given by them. I'll just read that. On 25/1/2001, petitioner.
Correct, we accept it. It is not in proper format. Then you will wait for it for 11 years.
No, but it was not in proper.
If it is 11 years, so many things you have to prove. This is an application of 166.
No, usually, that particular point of time, this was at 12 years and they have filed it in 11 years, I believe.
Well, can I pass on the judgment, my lord? Well, because
this is a petition filed under 166.
Well, I don't know. It's a WCM, my lord.
No,
Workman
workman's
compensation. Well, on workman compensation, my lord, after really a struggle, my lord, I was able to lay my hands on this judgment, my lord, on the issue, my lord, on the issue of.
Thereafter,
Lordship,
it was
kindly-
amputated.
Let's look at it.
Kindly
Give him a
come to.
copy of it.
I've
Yes,
given.
now they
Kindly
gave
come
me.
to para 9, my lord. Para 9, my lord.
Para 9.
Yes. Two issues arise in the present appeal. Firstly, whether there was sufficient cause for condemnation of approximately 9 years and 5 months delay in filing the application before the commissioner under 1923 Act. Secondly, the event the aforesaid hurdle is crossed, whether the relationship of employer-employee has been proved. My lord, the answer, my lord, is para 15. My lord. Para 15, my lord. Even on the ground of delay in filing the application before the commissioner, that is on 2/8/2004 also, the same deserves to be dismissed. Case put up by the appellants themselves was that they had not claimed any compensation against the owner of the vehicle, who is alleged to be the employer, while filing application before the tribunal. It was for the reason that they wished to claim compensation under the 1923 Act. Once that was so, this fact is being in their knowledge from the very beginning. Delay of 9 years in filing the application under the 1923 Act is certainly fatal for consideration of the claim by the appellants for award of compensation. In fact, the application before the commissioner was filed only after the proceedings in the MACT was concluded, and the appellants were not able to get any compensation in execution. The application before the commissioner was.
So here in this case was
There is no such ratio laid down by the apex court that wherever there is a delay
Well,
on the face of it, it has to be.
Well, the last line, my lord. Therefore, in our opinion, no sufficient cause is established for condonation of delay.
That all depends upon
Well,
each case.
in the
That we
in the
have to look
present
at
case,
it.
he was
What is the reason stated by him, and whether it is a sufficient cause or not, we have to look at.
Yes, my lord.
From the facts of each case.
Yes, my lord.
There is no blanket proposition.
True,
like
my lord.
that.
My lord,
So now
even this
please
was
come
not
to-
available, my lord.
No, please come to the claim petition. Give you have the TCA? Give that.
Exhibit.
TCA. I have his evidence, can I? My lord, I have the claim petition, my lord. Can I pass on, my lord?
I'm looking at it.
There's not even an application, my lord, if I'm correct, my lord. I've taken that ground as he has not even filed an application seeking condonation of delay, my lord. And his evidence, my lord, not a single sentence, my lord, explaining.
He's
the
working with the
corporation, my lord.
But what is this? The petitioner submits that petitioner has become 100% disabled and he has surrendered his driving license to drive heavy passenger
My lord,
vehicle.
we have given him change of card.
His leg was
My lord,
amputated.
under the, my lord, since our KSRTC, my lord, comes under Article 12, my lord, we have provided that the provisions of Disability Act would apply.
In those circumstances, there is no dispute about the fact that there was an accident.
Yes, ma'am.
And he lost his, it is not a simple case where that he has.
My lord, there was amputation, my lord. We have provided, my lord, change of card with pay protection. My lord, not a penny, my lord, has been reduced, my lord.
No, it was reduced.
And here is a case.
It was reduced. That was the say before me.
My lord,
Before
what has
the court.
happened is, my lord,
It was given
I
as
have
helper.
filed in detail, my lord, the affidavit of the administration department, my lord, who computes the salary. And I have produced, my lord, each document, my lord, in the present case. And the honorable court, my lord, directed me, heard at length, my lord, to say that his pay is not, because I'm required to protect, because he comes under the purview of Disabilities Act, my lord, where I am required to give him the change of card with pay protection. It is done in the present case.
So, what was his salary as on the date of the accident?
My lord, I mean, 4,500, my lord. 4,200, my lord, was the basic pay.
4,000?
5,002.
4,200. My lord, 1 second, my lord. I'll just.
The monthly salary as on the date of accident, what was the petitioner going was 5,002 per month, which I've stated in my appeal memo on the facts of the case itself. The appellant was working as a driver in KSRTC, so and so. Monthly salary was 5,002 per month. Later on, I was given as a helper. I don't say no.
What is the salary of
Yeah,
the
it was
helper?
reduced. That time it was reduced, my lord.
What is it? Because you're the claimant who is receiving the salary.
Yes, my lord. Those details were not there, so only this court directed them to produce those things, making a column. On 26/9/2024.
In fact, I have the memo ready, my lord, with the as directed by the honorable court, my lord.
Give him a copy of it.
My lord, he was given change of card, my lord, from April 2006. Until then, my lord, he was not working, my lord.
ABC column ಮಾಡಿ ಹಾಕಕ್ಕೆ photo.
April 4th to?
Sorry. My lord, April 4th, my lord, till April 6th, my lord, April, that is 2006. My lord, he was, my lord, given the salary, my lord, with the pay protection. Thank you. Pay protection, my lord, because it was not reduced, because he was not even given change of card till then.
They were asked to
So,
submit to from
Simultaneously, both of you can't argue. Let us submit and you can respond. Yes.
Then, my lord, thereafter, my lord, he was changed to the post of helper, my lord, helper A. Then, my lord, he produced the pay certificate, my lord, to say that his pay was reduced. My lord, there was a case before the labor court, my lord. After the labor court, the award was implemented. While implementing, my lord, before this accident, he has suffered many punishment orders, my lord. That was implemented altogether because the case was pending for about 9 years. The labor, therefore, my lord, in detail, my lord, I filed an affidavit with pay fixation, my lord. But kindly peruse that, my lord, along with the affidavit of the administrative officer. I think my learned friend was not there, my lord, because different counsel was appearing then. And I have produced, my lord, along with the how the pay was reduced. The pay was reduced or not on account of the change of card, my lord. It was on account of the implementation of the punishment orders.
Now, because he has come before the court with a delay, he'll not be entitled for interest.
My lord, what I submitted, in fact, my lord, before going into the merits of the case, my lord, this honorable court directed me to find out whether there is any possibility of settlement, my lord. I've been directed, my lord, to submit to the court. I've been instructed, my lord, to submit to the court that full and final settlement, we are ready to pay 2 lakhs, my lord. Even if he says that there was difference in payment, my lord, taking into consideration all those facts. Because he comes after 9 years, 10 lakhs, 9 lakhs, 31,000 is awarded. For 10 years, my lord, interest is
For
awarded.
example, without going into all that, if you have to make a calculation.
Yes, ma'am.
Provided the court feels that he is entitled for any compensation, what is the calculation? Tell the court.
My lord, the court has taken into consideration 100%, my lord.
No, no.
Here 100% would not come, my lord, because I was working in the corporation till his death, my lord, till his retirement. He died after his retirement superannuation.
No, he is no more. He's the LR.
After his superannuation, he died, my lord,
He has
because
not
he
enjoyed
worked,
the
my lord,
fruit.
till his superannuation. Then, my lord, till his superannuation, he worked, my lord, in the corporation. I have not removed him. I'm bound to give, my lord, because he comes under the disabilities, under the purview of Disabilities Act, my lord, where under section 47, I'm required to pay his, protect his.
So what was he doing with 100%
My lord,
disability?
helper, my lord. Only one leg was amputated, my lord, and he was working as a helper. Desk work was given to him. So long he worked, my lord. Because in all cases, my lord, in all cases, my lord, in the corporation, in fact, we have that problem, my lord, because the disability, they enter the corporation at the age of 25, 28 years. By the time they reach 30, my lord, they come up with a disability certificate saying that they are suffering from disability of not less than 40%. Leave alone, my lord, the respondent herein. My lord, even to those persons, my lord, those employees who approach the court with the certificate issued by the medical board concerned, stating that he is suffering from disability of more than 40%, I am required to protect his pay and provide a job, my lord, which he can perform. That's the law, my lord. That's the statutory obligation I am required to, my lord, discharge. Therefore, my lord, in all such cases, my lord, the disability cases, my lord, we have been providing job, my lord, to them. So this was what happened, my lord. After this kind of cases, what they were doing is they were changing the very pattern, my lord, of the salary, and protection used to be given.
We just do the calculation as it is, as it applies.
Yes.
So what's the salary?
My lord, salary only. As on the date of the accident, my lord.
4,200 according to you. According to him, it is 5,000.
His gross salary was more, but what he was going was
5,002 is
5,000 was the
calculation.
salary was going, but his gross salary as per the judgment itself is 8,560.
No, that's not the one. That is 8,653 is much later, my lord.
The
That
salary,
is,
the salary is
that is
mentioned.
of the year 2015. If your lordship could come to para 15, what the court takes is
So whenever you file the
2015.
application, we have to look at the day on which the accident has occurred, not at a later point of time. So according to you, let us just say it is 4,200, you are saying?
Yes, my lord.
So what is the calculation 4,200?
My lord, if his one leg is amputated, my lord, above knee. So even if your lordship takes it 50%, my lord, it will be 2,100 into relevant factor, my lord. He was aged
2,100 into what is the factor?
Into 181.37, my lord, is the relevant factor.
81.37,
my lord.
Into 50.
Well, it's only that is 60% of 2,200 will have to be taken, because, my lord, the disability, my lord, is 60%, my lord, of the salary is required to be taken. 60%
Oh,
of
4,200.
60% of 4,200.
You had already taken 2,100.
Well,
Coming to 19 lakhs, 4,385.
Well, 2,520 would be the amount, my lord. 60% of 4,200, my lord. 60%.
It should be 60%.
If it is permanent disability, my lord, the entire salary 60% will have to be taken. 60% of 4,200, my lord.
Have taken more less than what you're saying.
2,500.
4,200 into divided by 1. It comes to 2,520.
Yes.
In that case, it will be more.
More.
2,520 into 181.37.
181.37.
Into.
That's all. Only that much.
Only
no,
that much.
No multiplier. This itself is multiplier. 181.37.
Yes. Into 181.37. It's coming to 3,80,877.
Yes.
There are no other heads in this, medical bills and all.
And, my lord, now, my lord, for this period, my lord, he is being given full salary. He has drawn full salary, my lord, for this. Therefore, the difference would be, my lord, only in terms of increment.
Did you put it to your client? about their offer of 2 lakhs?
No, I'm not.
My lord, I
That's
informed
better.
this colleague, my lord. I
Because
informed
it's
this
not,
colleague.
there is no much difference between the both. Better instead of going into all that and again they're going for an appeal. If they're coming up with 2 lakhs, it's a good, tell your client. When? Let's have it on second. Second. This is matter on second. It is submitted that the insurance company, the case at RTC is ready to pay an amount of rupees 2 lakhs as a full and final settlement for getting instructions on second. Fine. Case next.
Serial number 35.
Yes.
Serial number 35.
Still by the insurer, my lord. Case of injury.
A.M. Venkatesh.
Involvement of vehicle is questioned.
It doesn't require translated copy.
It requires,
It requires-
entire documents are in Kannada, my lord.
Required.
Please.
Yes, post after vacation.
Please.
Serial number 36. Serial number 36. Will Shrikant Rao.
Senior is not keeping. Senior is not keeping. Kindly.
Tomorrow.
Tomorrow. Tell your senior no further time.
No, my lord, it is admitted by the petitioner, one of the petitioners.
That's what, no further. It is, even on the last occasion, the matter came up when counsel appearing to the claimant had sought for time. Today, is claimant or owner of the vehicle?
Claimant.
Claimant had
Claimant,
sought
sir.
for the time. Today also, again, time is sought. Finally, this is matter tomorrow. No further adjournments. Yes, next.
Serial number 37. 37. Guru Prasad B.R. for appellant.
Please.
M.
Case
Ashok
of
Kumar.
injury, my lord. Claimant's appeal for enhancement.
Under MBC Act or?
MBC Act, MBC. That's the date of accident is, my lord, 23/1/2014.
Please come to the table.
My lord, table, please. At judgment page number 20, my lord.
Page number?
Table, my lord. Judgment
table.
page number
Yes, yes,
20,
I see.
paragraph number 70.
What are the injuries?
My lord, sir, it is at page number 14 of the judgment, last line. 3 major fractures are there, my lord. First one, right thigh swelling, fracture, fracture of right femur shaft. Next one, my lord, right 4 cm to 1 cm bone deep over distal aspect of leg muscle.
We'll
Third
grant
one-
another 30,000 on that of pain and suffering for the 3 major injuries.
3 major injuries. Sir.
The 50,000 is already awarded.
No, but 40,000 for one grievous injury we are awarding. 80,000, yes. How many days he was in
23 days
hospital?
inpatient, my lord.
Huh?
23 days inpatient.
Attendant, food, nourishment. 23 days,
Please, my lord.
25,000. Then loss of immunity.
My lord, sir, what has been done, my lord, sir, he has suffered a disability of 20% to the right lower limb.
What is his occupation?
No, he's a
He
student.
was a student and
He was a
Student.
He was studying in final year BA, and also, my lord, he was.
According to the doctor, what's the disability?
My lord, sir, to the right lower limb 20%, left lower limb 14%. Totally, it was 34% to the both the lower limbs, my lord, sir. That has not been considered by the tribunal. Only 1 lakh rupees has been granted towards amenities in lieu of the same. That
So 1/3 would be
my lord, sir,
11%.
12%. 34, 12% may be taken because both the legs are, my lord.
No, as far as disability is concerned, may I request your lordship to peruse page 18 of the judgment.
18.
18. Here, what has happened, my lord, instead of considering, my lord, the loss of income, since he has stated that he is a student and he is missed one SEM, for a SEM, he has missed 50,000 has been
What we
awarded.
do, that is a different head.
Cost of semester.
What we do is,
No, for
the
the- for-
amenities as granted by the court, we will not
No,
take.
no, that is not the amenities. That is treated as income because your lordship may peruse.
Not like that, my lord.
No, we will
And
take
further,
the-
my lord, and further, my lord, 1 lakh has been given for the disability.
That is not the calculation to be done in this case. We will not go by what the court did. We will do a fresh calculation.
Then it would
all
have to be
go.
minus.
No, it will be minus.
Yes, therefore.
It will be minus, of course, but
Yes,
it gives the two heads. So loss of future income, picture is accident,
14 millers. 8,000, 8,500.
500, because he's a student, this thing will take 10,000.
Please, millers.
No. He himself admits that he was teaching and his income was 8,000. He himself admits.
Along with that, he was going
Yes,
to the
yes.
college.
No.
College
May
also
I
he was
request
going.
your lordship to peruse page number 90.
How much he said? 8,000?
8,000 he says. He was taking some tuitions and.
So 8,000 into 12 into.
Millers, apart from that, he was a student also. He was going to the college. So 8,500 notional income may be taken.
Yes. So 8,500 into 12.
12%, 12 into 18, 20.
18 into.
So disability 1/3, if it is taken 11.33, it would come.
We'll round it off to 12. It comes to 2,20,320. Then loss of, he lost one semester.
Loss. 50,000 has been granted by the
50,000
tribunal.
has been given.
That is a different head. Loss of his education.
What is that?
different
Only
head.
50,000 granted.
Loss of a semester. 50,000. And loss of amenities.
No. Disability gave one.
No, that I'm not granting.
Yes.
Different calculation. So loss of amenities, this is for 30,000 we'll grant.
Please.
Then he's earning, loss of semester has come. We'll not grant loss of again income on for the later period.
Yes, madam.
Then any future operation?
No future operation.
Medical expenses?
As it is.
Given as it is.
1,97,290. Legal expenses 10,000. It comes to 6,12,618.
As
The court had granted 4,08,698. Any confusion?
May know.
Pain and suffering 80,000.
Yes, ma'am.
Attendant nourishment 25,000. Loss of future income 8,500 into 12 into 18 into 12 by 100. 2,20,320. Loss of semester that 50,000. Amenities 30,000. Medical expenses 1,97,298. Legal expenses 10,000. Please come. The present appeal is filed with the claimant seeking enhancement of the compensation granted by the tribunal in MBC number 918 of 2014 dated 7th December 2016. The claim petition was filed seeking compensation of an amount of rupees 10 lakhs and the tribunal had granted the compensation as per the table given below. At para number 17 extract, the tribunal had granted an amount of rupees 4,08,698. When counsel appearing for the claimant submits that as per the wound certificate, the claimant has sustained 3 grievous injuries and the pain and of suffering, the amount that is awarded by the tribunal is on the lower side. Further, he was in hospital for 23 days and the court had granted only 11,400. The tribunal has granted only 11,500 for the attendant food and nourishment. It is submitted that he is working as he is studying BA final year. BA final year and earning he lost one semester. And according to the doctor, the disability is.
He lost one semester and have to reappear. I mean, he will.
The doctor has stated that the disability is 20% to the left leg and 14% to the 14% to the other limb, and the tribunal had not considered the 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 disability and ought to have considered at 12%. It is further submitted that the compensation that is awarded on all the heads is not a just and reasonable compensation. Next paragraph. Then counsel submits that the counsel appearing for the RTC submits that the respondent, the claimant is a student, and the court, in fact, for the loss of amenities and comfort and loss of income and medical expenses, has already granted an amount of rupees 1,97,000 to. What are the medical expenses?
1,97,000.
But it says loss of income and medical expenses.
It is it's wrongly.
No,
that has-
wrongly it is
wrongly it has been
described,
And
but it is a medical.
loss of medical expenses. For the medical expenses, court had already granted the reasonable amount, and the claimant is not entitled for any enhancement. Next paragraph. Having heard the counsels on his said consummation not required. As per the moon certificate, he had sustained 3 grievous injuries, and the head of pain and suffering this code is granted 30,000. Coming to the attendant and food nourishment, he is there in hospital for 23 days. This code is granting 25,000. Coming to the loss of future income, he is a student and he is a student who is pursuing his BA, and he has also lost 1 semester. This court is inclined to take the income, notional income for the year 2014, and it is 8,500 into 12 into 18. And when it comes to the disability, court ought to have taken the disability at 1/3 of what has been stated. Hence, this court is taking 12%. That is 12 by 100 is 2,20,320. As he lost a semester, this court is granting 50,000. Coming to the loss of amenities, for the disability of 12%, this court is granting 30,000. The medical expenses, as no interference is called for. In the light of the law later in Mekala, so also legal expenses 10,000. Altogether, the claimant is entitled for an amount of 6,01,618. Accordingly, the appeal is partly allowed, enhancing from 4,08,698 to 6,12,608. Enhanced amount shall carry 6% interest. Signatures.
Okay.
ಎಂಟೊಂದಾಗಿತ್ತು 4 ಒಂದಾಗಿತ್ತು 4 8 ಆಗಲಿತ್ತು 4 ಇದೆ.
ನನಗೆ ಗೊತ್ತಿಲ್ಲಪ್ಪ ಅದು. ನೀವು ಬೆಳಗ್ಗೆ ಹೇಳ್ಬೇಕು ಅದು ಮಾರ್ನಿಂಗ್ ಯೂಸ್ ಮಾಡಬೇಕು. ಯಾವಾಗ ಬಂದು ಅವಾಗ ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಮ್ಯಾಟರ್ 5 ಮ್ಯಾಟರ್ ಹಿಯರಿಂಗ್ ಆದ್ಮೇಲೆ ಅವ್ರು ಹೇಳಿದ್ರು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 4 ತಗೊಳ್ತಾರ ಮಧ್ಯಾಹ್ನ? ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್, ಲಿಸ್ಟ್ ನಂಬರ್ 4 ತಗೊಳ್ತಾರ ಮಧ್ಯಾಹ್ನ?
ಹೌದು.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
Hello, court officer? Hello, madam, court officer?
ಹೇಳಿ ಮೇಡಮ್.
Fourth list ತಗೋತಾರಾ?
ತಗೋತಾರೆ.
Thank you.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ಮೇಡಮ್
List number 4.
List number 4.
4. Serial number 60. 60.
60.
5,50,000.
5 lakh
50,000.
above interest without interest.
Including interest.
Including it.
It is submitted that the insurance company is ready to pay an amount of rupees 5,50,000 in addition to what has been awarded by the tribunal. Interest at 6%.
No, my lord, inclusive of interest.
Inclusive. A lump sum of 5,50,000 in addition to what has been awarded, and they'll file a joint memo tomorrow.
For Lok Adalat.
Just say tomorrow. We'll see Lok Adalat is there or not. And then Lok Adalat. Yes, next. Yes.
File number 33.
33. Yes. What are your instructions?
I appear for the, my lord, my apologies, I'm appearing online, I'm not keeping too well. I've spoken to the respondent, my lord. In fact, I asked her to speak to the child. The child's immediate response was, what will I do there the whole day? I don't have any friends there. My lord, if I may just permit you to make a submission. My lord, in matters of...
Take a friend also.
My lord, my lord, the child has her vacation. My lord, if I could just be permitted to make a 5-minute submission, because the image being put...
5-minute submissions, only 2 lines. What is the when it can be done?
My lord, if we have weekends available, my lord. Now, without prejudice to my rights on the main matter, during the period of vacation, the mother is willing for the child to spend the time during weekends with the father, my lord, as was ordered for this last weekend, my lord.
No, that is what is ordered by the trial court.
My lord, it's first and third Saturday, my lord, at the child visitation center. That is the order on which they have come to court, my lord. In fact, they had initially, if I will be very brief, my lord. This is a case where the mother has filed divorce petitions in 2022 because of physical abuse from the father, my lord. And I don't want to now spend time on merits of the matter, but we have produced on record the condition that also the child was in because of the abusive behavior of the father, my lord. My lord, after 8 months, the father has filed a petition for restitution of conjugal rights. In my petition, they filed an application seeking overnight custody, my lord. That application of theirs was allowed only in part, and the Honorable High Court on 3/9/2022 had passed an order permitting the father to meet the child every weekend, my lord.
What we will do is, now on the last occasion, the arrangement was
Saturday and Sunday, my lord. This is yesterday and day before yesterday, my lord.
Saturday and Sunday, 10
Yes,
to
ma'am.
6 p.m. Then
Yes,
what
ma'am.
will we do is, in addition to it, we will grant Wednesday also. When you are in Bangalore. When you're not in Bangalore, like the dates are also, I think they are mentioned in the morning. What?
Yes, she has
my lord,
mentioned.
from 21st.
May 21 to 28, lordship.
May?
21 to 28.
And also May 1st and 2nd, my lord.
No,
My lord,
May
but
21 to 28
And
and
May 1st and 2nd.
May 1st and 2nd.
if I may pass over just 2 photographs which show a completely different pictures and from what
My
she is.
lord, I am not saying anything about the recent visitation. It's been uneventful. I'm not making any allegations against the father at this point in time, my lord.
Yes. May 21st happens to be Thursday, from 21st to 28th.
Next month. Yes, 21st to 20th of next month is Wednesday to Wednesday.
So I'm just looking. So first and also second is not, she's not
May
available.
1st and 2nd.
May 1st and 2nd, my lord, which is a Thursday and Friday, my lord.
What we'll do is 3rd and 4th May, and again on 6th May, then on 9th and 10th May.
My lord, 9th is a Friday, my lord.
And then 10th and 11th, 10th and 11th, 10th and 11th, then 14th, 14th May, thereafter 17th and 18th May. Mother is leaving on 21st, right?
21st.
So we'll
The
grant.
mother and the child, my lord, from 21st to 28th.
Yes, sir. So we'll grant again on 20th May. She's coming back on 28th May.
Yes, my lord, 28.
28th May. And the school reopens on
9th of June, my lord.
9th of June. 28th May she's coming back. So again, 31st and 1st, then 11th, so 31st and 1st, then again on 7th and 8th. In between there is 4th, I think, 4th. So till school reopens, this is how it is. After the school reopens on Saturday and Sunday. And with this, we will dispose of this writ petition itself. Let it continue.
My lord, is the writ petition being disposed of on merits? Because, my lord, I had also filed an IA for modification because the order previously prevailing was that the child meets the father on every Saturday and every Sunday. Now, my lord, for 2 years, I had not challenged this order. It's only after 2 years, and the only reason I stress on this.
Now, with regard to the maintenance, the school fees and other things, already an order is passed. He has paid 1 lakh. He is paying. Let the court decide on the main matter itself.
My lord, the only submission is one of the grounds that I had raised for every Saturday and every Sunday is that while I do agree a father has rights to visit the child, my lord, and our intention is not to alienate, my only submission is that every Saturday and every Sunday the child is caught in visitation, my lord, having no time to spend. I may be heard on merits, my lord. This may be an interim arrangement. I may kindly be heard on merits post vacation, my lord.
No, in that case, we'll have, because some activities, she's 11 years old daughter, she'll be having some activities. We'll say every Saturday, instead of Saturday and Sunday, later, every Saturday, let him have the visitation from 10 to 6.
But that will be only one day in the week.
But
fair enough, my lord.
What the trial court has granted.
The trial court has reduced me from twice a week to once in 2 weeks.
Now we are making it once in a week, because what we have to understand also, child will be having her own work to do and all, and just like that they can't come and spend the whole
absolutely
time.
not. That's not our intention also, which is why I suggested, as your lordship has suggested, let the child come to my house and I will drop her back in the night. They scoffed at it. Let the child's bus passes through my.
Again becomes a problem. Please continue like this for some time. Happily with whatever time you have that Saturday, develop some bonding, and in between, and when things are going all right, then you can move another application before the court. That liberty I'll give.
Then that liberty, your lordship.
Yes, but not so.
No.
At least
we are at the stage of evidence now.
No, what we do is this is May. I think again December you get the vacation. At that point of time, you are at liberty. I'll say you can move an application in the change circumstances in the month of December. What do you say?
I will move it for the December vacation.
December vacation, and even any modification in this also in December you can ask. Yes.
Just one request, my lord, because I've been informed that the child goes for classes. We will of course share the schedule with the father. On the days that the child is with the father, he may kindly be directed.
Take care of that. He said he'll take care of that. So please come, give both the matters. Next matter also. Connected is there, I think.
No, my lord, it's just this one matter. They've challenged 2 IAs in the same order, my lord, in the same writ petition, my lord.
No, you said you are also questioning.
No, my lord, I'm the petitioner before the trial court, my lord.
No, that I understood. From your submission, what the court understood is that you have also questioned the order impugned.
No, my lord, I haven't questioned it, my lord.
Where is page number?
Impugned order is at page number 29.
29. The present writ petition is filed.
Operative at 45.
Questioning the orders passed in I number 11, I number 8 and 11.
8 and 11.
8 and 11. Dated
Dated 2/12/2022.
2024, whereby the family court has partly allowed the application. That is I number
11.
11. And dismissed I number 8. What is it for?
My IA was to give me more visitation, more access to my
IA
daughter.
number 8 is filed seeking more visitation, that was rejected. And IA number 11 is concerned. The father is permitted to visit the minor child on first and third Saturday after school hours at the Child Visitation Center, Family Court, Bangalore, till 6 p.m. Then counsel appearing for the father submits that the girl is 11 years old and they were residing together till 22. And the child had were sharing a good bonding with the daughter, and the daughter is 11 years old, and granting the visitation in the child visitation center, that too for such a short period, it will come in the way of the father and the child developing the bonding, and that the time that is granted is not sufficient. Then counsel appearing for the respondent as mother submitted that the father is not taking care of the responsibilities of the child, but is only asking for is agitating for his rights, and several contentions were raised on the last occasion. Then on 25/4/2025, this court passed the order, that operative portion of the order extract. And today, when the matter came up, it is submitted that as per the order passed by this court, the visitation went on very well. And it is a submission of the father that the visitation went on very well. And also he has handed over, it's a check.
A check, my lord.
He has handed over the check for an amount of rupees 1 lakh. And he submitted that within 1 month from today, again he'll be paying the other 1 lakh. Likewise, every 1 month, he'll be completing the amount of the 4 lakhs which he is supposed to pay. It is submitted that considering the ensuing holidays and how the visitation went on the last occasion, the further time may be granted for the father to spend time. Then counsel appearing for the respondent mother submits that the daughter has extracurricular activities and spending, if more time is granted, as the girl is not having any friends in the said locality or there, she'll get bored, and it is submitted that the court may not extend the time, considering the fact that the father is ready to pay the educational expenses and he has already paid 1 lakh and ready to pay the other amount, and also the visitation on the last as per the earlier order went on very well. As per the submission of the father, this court deems it appropriate to pass the following order. And before that, other submissions, it is submitted that on May 21st to 28th and May 1st and 2nd, the mother is not in Bangalore, and on those days the visitation may not be granted. Next. The
Mother and child, my lord.
Mother and child. The father, like while I am reading out these dates, please look at the calendar and also whether that falls on some other days.
Yes.
The father is entitled to exercise the visitation on 3rd and 4th May, 6th May.
My lord, 7th is a Wednesday, my lord.
7th is Wednesday. 7th May, 10th and 11th May, 14th May, 17th and 18th May, 20th May.
21st, my lord, is the Wednesday.
21st May. Then
21st is not
my
there.
lord, my apologies, my lord. My lord had indicated 20th because we're not there on 21st. My apologies, my lord.
20th.
I was engrossed.
Yes, 20th May. Then 31st and 1st, 31st of May and 1st of June. Then 4th of June and 7th and 8th of June. Next, after the school reopens, the father will have the visitation on all these days between 11 a.m. to 6 p.m.
10 to 6 was the last. 10 to 6 was the last.
No, it was 11. It was
11.
It was corrected by the court. 11.
Oh, I see.
11 a.m. to
No, yesterday's order was 10 to 6.
it was 11 a.m. It is there in the order. 11 a.m.
11 to 6.
11 a.m. to 6 p.m. The mother shall hand over the custody at 11 a.m. and shall pick up the child at 6 p.m. Then,
My lord, again, I'm sorry to interrupt. The mother won't be able to pick up at 6 because she'll be in office. Father may be please direct her to.
he has no difficulty yet. I think last time.
No,
he
he
said
has no, he has, yes.
The mother will drop the child at 11 a.m. and the father will, mother will drop the child at 11 a.m. and father will drop the child back at 6 p.m. After the school reopens, the father shall exercise a visitation on every Saturday between 11 and 6 with the same arrangement. And on any of the days when the girl is with the father, if the girl is with the father and if there are any extracurricular activities to be attended, the father shall accompany the child and accompany the child. Next, this is a GNWC of?
My lord, it's in my divorce petition, my lord.
That as this court has already made sufficient arrangements, which will help the father to develop the bonding. This arrangement shall continue till the winter vacation, and before the winter vacation, the father is at liberty. Father or the mother is at liberty to come up with an application for seeking any modification or further seeking any modification or extension of the time of visitation basing on what has transpired in these visitations, and the court can pass appropriate orders on such application. Accordingly, the petition is disposed of.
Could I kindly request for a quick disposal of the petitions before the trial court, my lord?
Of which year?
22.
22.
21.
And which is the court?
First additional principal family.
Bangalore.
Yes.
Bangalore still 14 is going on. Yes.
List number
Obliged,
2, serial number 4.
List number 2.
Pauline Priyanka, petitioners.
Morning,
What's the name?
Pauline Priyanka, ma'am. That's my name. The advocate's name. The advocate's name
Submitted
is...
that as per the memo filed by the,
Yes,
as per the orders passed by this court. The hand summons were served on the counsel appearing with the respondent before the trial court. That is Mr. What is that name?
Badigir Kundalingappa Mallappa.
Badigere.
Yes, ma'am. Kundalingappa Mallappa.
Mallappa. Registry is directed to print the name of the counsel in both the cases. This is matter after vacation.
Yes. Because, my lord, just one submission, my lords. In CP 70 also, my lords, there was a process, the notice was ordered, and we also sent.
Same advocate.
Yes, ma'am. So, no, for the party also they have sent, my lord, but he is not turning up in this matter. Earlier date, in CP 70, my lord, which is a connected matter, the court had ordered for a notice. And process was done. Yes.
He is the advocate, the respondent advocate same.
Yes, yes. Same.
That's what I already said. To write to take to print the name of the advocate. Next.
Grateful, ma'am.
Next.
List number 1, serial number. List number 2, serial number 38. Continue.
38. Yes, 38.
I appear for the respondent.
Appellant in this matter, my lord.
Insurance company.
Please, please. Insurance company.
You are on what ground?
No, my lord, the petition is filed under ECA, Employment Compensation Act, my lord. The trial judge, while awarding the compensation, has calculated the compensation as if it is a motor vehicles claim.
What do you say?
That's
It's a petition filed under employees
So we will
compensation.
make the calculation as per the.
Please.
My lords,
If he
one
presses on
submission.
MCA, my lords,
One submission, my lords, I have not raised any counter claim, but the fact, if this honorable court permits me to read out a fact, there is a near amputation of the arm. Near amputation.
No.
The only reason that trial court,
Difficulty is you have already filed a petition. No, whether you have filed a counterclaim or not. No, if the court is adjudicating this under the workman compensation act,
yes,
we will make the calculation as it is.
because what
If you are
happens,
entitled for anything more also, you will get, or then they will withdraw the petition.
my lords,
let's please
in
come.
case if he presses as if it is, he himself, it's a ECA, my lords.
First of all, as per the ECA, we make the calculation. What
Please,
is the
my lords,
amount it
please, my
comes,
lords.
we'll see.
The
Which year is
calculation is, my
accident?
lords, my lords may kindly see, he
Which year is
takes,
the accident?
my lords,
Which year is the accident?
2013, my lords, sir.
As per the notification, it is 8,000 or more?
Please, my lords, 8,000.
What is the disability?
It's taken amputation of right
Amputation
hand.
of right
1/3/2013 is the date of accident, my lords.
Amputation is 50% disability.
Please,
yes,
70% schedule injury, my lords.
As per 70%.
70%. 8,000, 70%, the multiplier, the
No, we
factor
have to take-
applicable is,
No, we have to take 70% of the.
I'm not disputing. We can,
8,000, what is 70%?
ಮಾಡು ಬೇಗ ತಗೋ. ಅಲ್ಲಿ ನನ್ನ ಕ್ಯಾಲ್ಕುಲೇಟರ್ ಕೊಡ, ಇದು ಕ್ಯಾಲ್ಕುಲೇಟರ್.
5,600.
Please, ma'am.
What is the multiplier?
21, factor is 219.95 because he is aged
19?
0.95.
Do you have any dispute on this?
no, with regard to this, sir.
It comes to
12,31,720 if I'm not wrong.
5,600 into
7.
Yes, it's coming to 12,31,720. Then medical expenses, are they not entitled?
4,80,000. 4,80,000 is the medical expense. 80,000.
80,000.
Yes.
So that's a one. So plus 4,80,000. It comes to 17,11,720. And what is the amount granted?
Amount is 12 lakhs and odd minutes. No. 13,27,200.
There may be some calculation error.
No, we forget about that calculation.
Please, ma'am.
But this calculation. How to make, you tell the court, accordingly we will make correct calculation.
Malus, 60% of his wages has to be considered, Malus, not complete wages. As per ECA Act, 8,000, 60% of his age wages has to
We
be
will make
taken,
it again.
and then 70%. That's why I was just wondering. I have calculated. It would come to 70% would come to 7,39,032 because 60% of his wages has to be considered for the purpose of calculation. Out of 60,
Let's do it. So 5,600 into 60 divided by 100. It comes to 3,360.
3,360 into 219.95.
Into
219.95. That would be 7,39,032. Plus medical expenses 4,80,000.
No, where this disability is going?
Disability is not at all there.
Malo 60% of
You
Malo
said 75% is his disability.
Malo 60% of wages would be 5,600 for the calculation purpose. 5,600, 70%.
70% out of 5,600 is
5,600. For calculation purpose, photo schedule, okay, easy act. 60% of his wages as
Forget how it is calculated. Give the actor. Actor.
Section 4.
Where will you get this? Amount of compensation.
Section 4 minus.
Where death results
Per
from the injury.
B minus.
Huh?
B.
Where permanent total disability results from the injury.
An amount
equal to 60% of the monthly wages.
Of the injured multiplied by relevant factor, whichever is more.
So 60% of the salary is?
65,600.
It's not 60%. That is 70%.
Out of it, 70% is disability.
No. First of all, you're saying 60% of the salary. What is that amount you have to tell?
8,000 into 60%. 4,800.
$4,800.
Please, minutes.
4,800 into the factor 219.95.
Please, minutes.
Into it comes to 10,55,760. Then medical expenses of 4,80,000. Even at that way also, his amount he's getting is more than that. It is going to 15 lakhs.
I mean, my loss may kindly have the matter tomorrow. I'll seek instruction and withdraw.
Tomorrow, Pater.
Please,
much.
List number 3. Serial number 1. Specially listed matters.
My lord, both the appeal is by the husband. So far as the first writ petition is concerned, my lord, the petition for divorce filed and
Reform those 2 cases to register in statistics. Last. Yes.
my lord, so far as first writ petition is concerned, husband filed petition for divorce under 13(1)(1)(a) and 1(b), cruelty and desertion. My lord, during the course of evidence of the, my lord, the PW1, that is the husband, my lord, evidence is closed and the case has been listed for cross-examination.
MC of which year?
2020, my lord.
2020. You are for the?
I am for the husband.
Husband filed the MC for divorce.
Yes, my lord. My lord, once, my lord, the evidence has been closed and the case has been listed for the evidence of the defendant. Again, the application has been filed by the wife, my lord, and it is reopened. Now it is the case of cross-examination of PW1. Now husband filed the petition, my lord, under order 18 rule 17. My lord, to produce some electronic device. My lord, that is the, my lord, the downloaded by the wife, my lord, the personal computer. My lord, the trial court, my lord, sought for, my lord, the reopening PW1 for further examination. The trial court rejected the application solely on the ground that, my lord, the husband seek divorce under 13(1)(1)(a) and 1(b), not under 13(1)(1)(a), that is for the adultery. Hence, my lord, the considering the
purpose you want to file those documents.
My lord, it is reflected, my lord. I would like to take, my lord, attention in page number 21. Annexure A. My lord, the second line. It is true that in para 6 of the petition, the petitioner has asserted that the respondent is having a relationship with one Praveen. It is pertinent to note that the petitioner has filed this petition under 13(1)(1)(a) 1(b) of the Hindu Marriage Act against the respondent. seeking divorce on the ground of cruelty and desertion. The petitioner is not seeking divorce from the respondent on 13(1)(1)(a) of the Hindu Marriage Act on the ground of adultery. Since the petitioner is not,
Is it relevant now?
my lord, it is relevant, my lord, in order to prove the desertion and cruelty. My lord, the document is very much prepared for, my lord, for the evidence. My lord, for the last 2 years, my lord, ever since as on the date of filing the petition, my lord, that is 2000.
Did not file all these documents.
My lord, subsequently I had acquired.
Where is
Yes,
that IA?
application.
Where is that IA? Where did you say?
Annexed at the ink page number 40.
Let's see that.
And para 40, ink page number 41 is the affidavit. It is respectfully, my lord, they submit that I pleaded in the petition that the respondent is having so and so, and the communication that the person through telephone and the same is recorded by herself. And after knowing the fact of the petitioner, myself downloaded the same on the electronic devices. Hence, I want to demonstrate the same before the
You
honorable
didn't
court.
say anything why you have not produced during your chief and
Next,
cross?
I have stated, I respectfully submit on the previous hearing dates, I could not able to trace the said electronic evidence is one of the helpful evidence to prove my case. Hence, I pray to allow the annexed application in terms.
On what ground you are seeking divorce? On the ground of cruelty and
Adultery and
desertion.
cruelty, my lord.
If you make out those grounds, that is sufficient. Whether you prove it or not is not necessary.
My lord, so far as desertion is concerned, ever since from the date of filing the petition, my lord, she is, my lord, separated for a period of 2 years as on the date of filing the petition. For the what purpose, my lord, she is, my lord, separated. Have to prove the same.
She had deserted for the purpose of staying with somebody else is not the question. Whether she has deserted you, left the matrimonial home, that is the ground for granting divorce.
But,
So, court had rightly held. What is the next application?
My lord, the next, my lord, the proceedings initiated, my lord, under 125 CRPC.
Let us see that.
Second one.
Give the next matter. Next matter. Yes.
Lord, the proceedings initiated by the wife, my lord, under 125 CRPC against the husband, in which, my lord, the 9,000 maintenance has been awarded to the wife and 5,000 to the daughter, my lord. The said annexure A is the, my lord, the said order has been called in question before this honorable court at the
Filed an application under
and 127. So I sought for modification of the order, my lord, in view of the change in circumstances. My lord,
How much was granted?
9,000 to wife and 5,000 to daughter.
What are the change circumstances?
My lord, change circumstances is that, my lord, the one is, my lord, she is, my lord, I am doing the electronic device business. My lord, subsequently, my lord, I wind up on account of, my lord, the corona, my lord, during the corona, my lord, I wind up. And the GST authorities has also issued the notice, my lord, for winding of the business. Secondly, my lord, she has acquired also some properties, immovable properties. My lord, my wife, my lord, she has acquired some immovable properties. Apart from that, my lord, she is also gainfully employed. She is also working. My lord, I have produced those documents.
Come to the discussion. We'll read the paragraph.
Yes. My lord, relevant para, my lord, the ink page number 34, para 19 onwards. The respondent has produced the Xerox copies of the judgment and decree. Ink page number 34, internal page 16, my lord.
We'll read from paragraph number 16.
16, please, my lord.
Yes.
The records produced by the respondent goes to show that the petitioner, when working as a teacher in the Arvind International School, Girigodra Parlia Gate, Madur Kunigal Road, and draw the salary of for the month of May 2014 to August 2014 and November 2018. The said document goes to show that petitioner number one working as a teacher must prior to the filing of the petition. At the beginning, when she married the respondent, now the respondent was contented that the petitioner one working as a teacher in Chaitanya Techno School, Katsandra, and drawing the salary of 18,000 per month. As noted above, the respondent has taken such contention in objections filed in IA number 2 also. The respondent has not placed any material to show that the petitioner number 1 is presently working as a teacher of Chaitanya Techno School at Katsandra and drawing the salary of 18,000 per month. It is pertinent to note that the respondent has filed IA number 6 under section 91 of CRPC seeking summoning of the documents related to the appointment and salary certificate of the petitioner from the Chaitanya Techno School, Katsandra, Tumkur, and the Arvind International School, Girdigodarapalya Gate, Madhu Road, Kunigal Taluk, Tumkur district. The petitioner supposes the IA number 6 by filing the objections. After hearing both the sides, the court by its order dated 22/4/22 rejected the IA number 6 filed by the petitioner at the cost of ₹1,000 payable to the.
Where is this right to application filed under the Right to Information Act? You have a copy of it?
Application filed?
Under Right to Information Act with regard to her employment.
Presently, it is not.
Yes, read.
Para 18. The respondent has produced the Xerox copy of the application filed under Right to Information Act to the Public Information Officer, Varin International Residential School and College, Dodas Gate, Kunigal Taluk, Kulur. The content that the petitioner number 1 working as a teacher in the said school and sought information about her salary. It is pertinent to note that the objection statement of the respondent is totally silent, and the petitioner number 1 is working as a teacher in the said Varin International and Residential School and College, and she is drawing the salary. The respondent produced only the application filed under Right to Information Act seeking information, and she has not produced any document to show that petitioner number 1 working as a teacher in the Varin International and Residential School College, and she is drawing the salary. The respondent has produced the Xerox copies of judgment and decree dated 2/1/2016 passed in OS, passed by a principal civil judge and JMFC Gubbi. Content that petitioner number 1 has got a share in the property in her parental house. No doubt it is true that as per the said judgment and decree passed in OS 3/25/2011, the present petitioner number 1 is entitled so and so. Next, para 20.
I've read the entire order. Yes, you can make your submission.
My lord, so far as my lord, the in view of the changed circumstances, my lord, I wind up my business, my lord, in order to, my lord, the established, my lord, GST authorities, my lord, have issued notice to the petitioner, my lord, have produced the same also. Apart from that, my lord, she is working as a teacher, my lord, have produced, my lord, the salary extract of the salary before
Which is before filing of the petition.
that is filed under 127 CR along with application.
File that salary certificate which you have filed is much prior to the petition filed by the wife. So that is not relevant. And according to her, she worked then and later she is not working. No other material on record to show that she is working.
So far as, my lord, the acquiring the properties, my lord, the immovable property, the same has been admitted by the trial court.
How will it come in their way? Because she inherited the property. It is not that she purchased the property.
That is her, my lord, the under the partition, my lord, she acquired. And so far as, my lord, the winding up of the business of the petitioner, for which, my lord, GST authorities has issued notice to the petitioner.
That is not sufficient. You should be able to place before the court that your statement of assets and liabilities, which you have filed earlier, and now the income varies from that day to this. Please come.
I leave it to court.
The person, WP number 28169 of 2023. WP 28 is filed, agreed with the orders passed in I number 7 in MC number 141 of 2020, dated 9th October 2023, whereby the tribunal had dismissed the application filed by the husband under section 151 read with order 18 to 17 of CPC to recall PW1 to produce some electronic evidence. It is the case of the husband that the wife is having illegal relationship with one person and she communicated with that person through telephone, and the same is recorded by herself, and after knowing the fact, the husband has downloaded the same to one electronic device. Hence, he wants to produce and demonstrate the same before the court. The family court had dismissed the said application and observed that on 6/3 on 1/12/2022, it is on behalf of the respondent partly crossed PW1, and subsequently, in spite of sufficient opportunities, the respondent side not further cross-examine PW1. Therefore, on 1/12/2021, the court had taken as further cross-examination of PW1 nil, and at the request of the counsel for the petitioner, adjourned the case for further evidence of the petitioner. In spite of sufficient opportunities, the petitioner side not adduced further evidence. Therefore, on 23/2/2023, by rejecting the prayer of the petitioner side, posted the case for respondent evidence on 6/3/2023. On 6/3/2023, at the request of the counsel for the respondent, adjourned the case to 17/3/2023 for respondent evidence. On that day, counsel for the respondent filed IA numbers 5 and 6 to recall PW1 for further cross-examination. In spite of sufficient opportunities, the petitioner side not filed objections to said IA numbers 5 and 6, and on 22/5/2023 allowed the said IA 5 and 6 and permitted the respondent for further cross-examination of PW1. Subsequently, the petitioner changed the advocate and filed this IA number 7 seeking recall of PW1 to produce some electronic evidence by adducing further chief examination. The family court observes that the husband is not seeking divorce from the wife under section 13(1) of the Hindu Marriage Act on the ground of adultery. He is seeking divorce on the ground of cruelty and desertion. When he is not seeking divorce on the ground of adultery, the documents which he sought to produce before the court are not relevant. Hence, the court felt that there are no grounds to recall him to adduce further evidence about the alleged electronic evidence and accordingly dismissed the petition. Then counsel appearing for the petitioner submits that the court ought to have allowed that application as the evidence which he is going to produce would show that the wife is having illicit relationship with another person, and the court would be able to adjudicate the dispute between the parties. And the writ petition needs to be allowed. Though notice is served on the respondent, though on the last occasion, there is no representation on behalf of the respondent. Having heard the counsel for the petitioner, listed this matter as part heard. Today also, there is no representation on behalf of the respondent, as the MC of the year 2020 is stayed by this court, and as such, this court is proceeding with the matter, and these cases are specially listed under the caption specially listed matters. Hence, this court is proceeding with the merits of the matter. Next one. Having heard the counsel for the petitioner, our husband, peruse the entire material on record. As rightly observed by the court, the MC is filed seeking divorce on the ground of desertion and cruelty. Now, the cross-examination of the PW1 is completed. Now, at this time, at that juncture, this application is filed, whereby he wanted to place before the court certain conversations between the respondent wife and the third party with whom she is having a illicit relationship. If the petitioner is seeking divorce on the count of adultery, no doubt those documents are relevant for proving this case, and even at a belated stage also, court would consider the relevancy of it. But in this case, for the ground that is raised is cruelty and desertion, for proving the said ground, these documents are not at all relevant, and the court had rightly rejected the application, and this court finds no reasons to interfere. Accordingly dismissed.
May make one submission, my lord. Kindly fix some time bound, my lord, to dispose of
In fact, if the stay is vacated, they will dispose of this matter by September. No time bound is required. That is how they are listed.
Please.
Huh? No. Next matter order has to be passed. Next WP 1566 of 2024. Agreed with the orders passed in criminal miscellaneous number 21 of 2021. No, in IA number 7, in criminal miscellaneous number 21 of 2021 dated 17th October 2023, the husband is before this court. The court had granted the maintenance of an amount of rupees 9,000 and 5,000 respectively to the wife and the daughter. Then the present application is filed by the husband under section 127 of CRPC for modification of the order dated 22/3/2021, 21 passed on IA number 2. It is a case of the husband that the wife is earning and working as a teacher. She has acquired certain properties, uh, and she's also having independent, and she's working, she has acquired the property and she has means to maintain herself. And further, he has closed his business, and even the GST have issued the notice. Which shows that the business is closed. And in these circumstances, the amount of compensation that is awarded needs to be altered. Next paragraph. Same in this also, respondent. The land counsel for the, before that, land counsel for the petitioner submits that the tribunal, the family court had failed to consider the same and dismiss the application in the light of the fact that she is already earning and she also got a property in a partition suit. The court ought to have allowed the application filed under 127. Respondent same like in the other case. Having heard the counsels on either side, counsel for the petitioner, husband, peruse the material on record. It is a case of the husband that the wife is earning. For that purpose, he says that he has filed an application under the Right to Information Act. What is the information that is received under the Right to Information Act is not placed before the court. It is a case of the wife that she was working before the filing of the petition, and all the documents that were filed by the husband only shows that she was working before the petition, but no material to show that she was working after the petition is filed. In those circumstances, the court cannot consider the said submission of the land counsel for the petitioner, and rightly the court had held that there is no material to come to such conclusion. Then coming to the income of the husband, if by virtue of any subsequent changes or change circumstances, he is not having the same income, he would have filed the statement of assets, liabilities, the revised ones, to show that is also not filed. Then the third contention is with regard to the properties acquired by her from a partition suit. If they acquire a property in a partition suit, that cannot be a ground for the court to alter the amount of compensation that is awarded. On all the three counts, the court has come to the conclusion that no modification is required. In the considered opinion of this court, the court had rightly considered and rightly dismissed the application, and this court finds no reasons to interfere. Accordingly, dismissed.
Please.
Yes.
VB Sidramaya for petitioner.
Yes, raised an objection regarding maintainability of the writ petition, my lord. My lord, this writ
Is filed
petition,
against which order?
interim order passed in MC by the family court at page number 22. It is maintainable, my lord. Wrongly it has been raised.
What is that? Let us see. What is that 22 order?
My lord, petitioner has filed a petition for restoration of conjugal rights at page number 22, annexure E. Respondent has filed an IA for interim maintenance.
How much is granted?
My lord, 7,000 to wife and 5,000 to daughter, son.
What is the income of the husband?
My lord, husband is not working. Both husband and wife were working as a lecturer in.
For the husband?
Please, my lord.
You are for the
I am
husband.
for the husband. My lord, he was met with an accident.
And have you filed your statement of assets and liabilities?
No, that has not been filed.
Why you are not filed? Without filing statement of assets, as envisaged by the Honorable Apex Court, you cannot afford to come before the court and say that I have no income.
Yes. I have to inquire, my lord, whether it is
Not
filed.
inquire. If
Before
it
the
is there, court would have
family, before the
recorded.
family court, it might have been filed.
No, if it is there, it would have been recorded by the court. Please look at the order. You're an
Para
MTech
para number
graduate
20, page 47.
and that is employed in a software company, which makes out a case that he is gainfully employed, able to pay. This court is opinion inter-monthly needs to be just and reasonable. No.
Yes.
What is the material for the court?
Kindly see the para 26, page 26, para 9, my lord, last para.
Which 26?
Petitioner, yes, my lord.
Yes, I've already read that.
Yeah. Kindly see, my
No,
lord, para.
no dispute that they have to file the husband has to maintain. Then wife has come to the court, she should say, what is the husband's income?
Kindly see,
And husband is there, what he has said, what is the consideration by the court? We'll set aside this order and let the court decide it. You both of you file your statement of assets and liabilities.
Kindly see, my lord, page 48, my lord.
48.
Yes.
Hmm.
In
para number 21.
21. Now, this court has consider the quantum of maintenance to be awarded to the petitioners.
What is this order at page number 28?
This is my lord, judgment of the criminal miss 107 of 2018.
Correct.
Filed by the
Which is impugned now.
Now, my lord, the petitioner filed in the order annexure, my lord. The petitioner filed another RPFC is also filed.
That is a different proceedings. Respondent has filed
But
a,
already the final maintenance is awarded.
that is in different case, my lord. RPFC.
Same order.
No.
That
No. No.
in your interlocutory application, there cannot be RPFC.
No, RPFC is a separate proceedings under 125 CRPC. She has initiated another proceeding that is not a subject matter of this writ petition.
Between the same parties, how will
Same
there
party.
be one final order in criminal miscellaneous?
My lord, as in
another
the different proceedings she has filed.
What different proceedings?
Under 125
CRPC is only one section for that lady, only one opportunity to file.
Yes.
And then
There she has filed 125 CRPC petition. Here in the restoration of conjugal rights petition, she has filed application for interim maintenance in this case. I have
there already you are getting.
Please, mother.
There already you are getting.
There I have filed.
There you are already getting.
Yes, madam.
You are getting the maintenance in criminal in other proceedings.
Yes, madam.
RPFC, I have filed RPFC and
Stayed in the proceedings.
stay has not been granted.
Stay proceedings.
It's not been granted in RPFC.
At least facts, I think I can have one statement from both of you. On law, you may have different views. At least facts will be one and the same.
Yes.
Same.
So, what is the maintenance that is received by the wife as of now?
Same order, in the another proceedings is also same 12,000.
Then shall I allow this petition? What same order? Against the same order, let's see the order. Please come to the.
Well, both orders are different orders. That may not be correct.
So this is arising out of criminal miscellaneous number 107 of 2018.
Yes, ma'am.
This is filed under 125 CRPC.
Yes.
This is questioned by him by filing a RPFC.
Yes.
Court has not granted any interim order. Then you are receiving an amount of rupees 7,000 and 5,000. That is how much? 12,000 you are getting there in the criminal miscellaneous. Now again you have filed another application in the MC. That is IA number
7.
Again in this, according to him, court had granted the same amount again. Then how much it will become? 12 plus 12, 24. Parter tomorrow. Get instructions. No more time on this. If you are already getting it, we'll set aside this order.
Yes.
Yes, next.
3. Cell number 3.
Appear for petitioner, my lord.
K. Ravi Shankar.
I'm filing NOC Wakalat, my lord, please.
What is this petition? Let's see first. Yes.
Kindly permitted to file Wakalat, my lord. NOC Wakalat, please. Today only I received this.
Why are you filing, Baba? You should have filed it in the registry. Order 6 Rule 17 CPC. We have to hear this, file your wakalat, whatever you want to do. This is matter on second.
Cell number 4.
No further adjournments will be granted. List the matter on the second. Yes, 4.
Not informed, appear for
Matter,
respondent.
my lords, I have instructed to file NOC wakalat in this matter, my lords. I praise for a short accommodation.
Second, not more than that.
Please, my lords.
List this
Second.
matter on second. No further adjournments.
There is an interim order, my lords. It may be continued.
It is there till that day.
Oblige me.
So, these two matters also which are discussed till the distress tax today itself. Yes, call the matter. Next is.
My lord, one submission I want to make. My lord has already calculated the compensation. My lord adopted multiplier of 18, but it is 16 is the proper multiplier. My lord. 2 multiplier, my lord, wrongly calculated. So by adopting the multiplier of 16, my lord,
16 only applied.
16 others. My
But it comes to-
learned friend.
My lord, it comes to 12,76,000, my lord.
Yes.
Lordship was telling 14 lakhs, my lord.
No, 12,76,800.
Yes. I also under the
Exactly.
same impression, but my learned friend is telling it is 18 is adopted. But as I understood, my lord has correctly adopted.
6650 into 12 into 16. 12,76,800. 88,000, 36,000, 10,000, 14 lakh, 10,800.
Yes.
6% interest for the enhanced amount.
Sorry, from Friday actually I am waiting for only for this case.
Yes, you have to wait for your client.
No. Since they
Present
it is for
application, appeal is filed, agreed with orders passed in MVC number 676 of 2017, dated 18 June 2018, whereby the tribunal seeking enhancement of the compensation granted with the tribunal. The application is filed under Section 160 of the Motor Vehicles Act, seeking compensation of an amount of rupees 40 lakhs for the death of the deceased in the road traffic accident. The tribunal has granted compensation as per the table given below. The counsel appearing for the claimant submits that the tribunal has taken the income at.
no, it is not. Income is not
No income
considered.
has been taken.
Globally granted 1 lakh towards love and affection, 15,000.
The tribunal has granted 1,15,000. It is submitted that, and for the loss of loss of dependency, no amount is granted by the tribunal, and the amount that is granted is not just unreasonable. Then counsel for the respondent, insurance company, submits that the tribunal had rightly granted the compensation, and no grounds are made out seeking enhancement of the compensation. Next paragraph. When it's a case of death, the court has to calculate the compensation under the head of loss of dependency. The claimant, this accident had taken place in the year 2016. Hence, as per the notional income, this court is taking the income at 9,500. What is his age?
31 years, my lord.
Future
40%.
prospects at 40% will come to 3,800. The income of the claimant is 13,300. How many are the claimants?
My lord, 2 brother and sister. My lord, 50% is to be deducted.
Loss of
50%.
dependency was rejected because they were major, my lord, at that time.
50% is deducted towards personal expenses. Then comes to 6,650 into 12 into 16 is 12,76,800. For towards the consortium 88,000, general expenses 36,000, and in the light of the law laid down in Mekala so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 14,10,800. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,15,000 to 14,10,800 The enhanced amount shall carry 6% interest. Next.
Cell number 2. Sri Harsha AK.
For appellant, my lord. Actually, on last date of hearing, 15,000 amount was settled, my lord, plus 6% interest, my lord. We request the honorable court to pass the judicial order, my lord.
Is that 15,000?
15,000 plus 6% interest, my lord. Actually, trial court has passed global compensation for 10,000.
Total compensation and the 15,000.
Please. Renka madam was directed to appear this case, ma'am. 15,000 settle ಮಾಡಿದ್ರು ಮೊನ್ನೆ 15,000 plus interest ಪ್ರದೀಪ್ ಅವರು ಪಾರ್ಟೆಡ್ ಅನ್ಕೊಂಡಿದ್ರು ಅದು ಇವತ್ತು ಬಂದಿದೆ ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿ 15,000 plus interest.
The for respondent insurance respondent KSRTC
serial number
Renuka HR Renuka is at take notice. Next, agreed by the order passed in about passed in MVC number 693 of 2014 dated 1st September 2018. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 10 lakh. 10 lakhs for the injuries sustained by the claimant in the road traffic accident. It is the case of the claimant that he had sustained.
Communicated.
He has travelled in KSRTC bus on 8/5/2014 and sustained
communicated fracture of right lower limb.
Fracture over lower right knee, and because of that, and the claimant has spent huge amount towards medicines and for also for under the other heads. Without considering all these aspects, the court had granted compensation of
10,000.
10,000. Considering the fact that 10,000 and the amount needs to be enhanced, and counsel appearing for the RTC submits that the tribunal had rightly considered and granted the compensation, and there are no grounds to interfere. Though there is no other evidence adduced before the
Disability is not produced.
to the other doctor evidence, though the doctor evidence, the evidence of the doctor do not support the case of the petitioner appellant that there is a disability. However, the fact remains is, as per the wound certificate, the claimant had sustained a grievous injury. Considering the same, this court is inclined to grant an amount of rupees, an amount of rupees 25,000, which is already against the awarded compensation of 10,000, and it carries 6%
Please.
interest.
Not a notice to respondent number 1 may be dispensed on, ma'am.
Memo is filed seeking dispensation of notice to respondent number 1. Dispensed with the risk of appellant. Next. 3. How many days? 4. Number 1/20 is filed to condone the delay of 409 days. Same condone on condition that he will not be entitled for the same. Yes, 3.
Cell number 3. Lakshmi Shah.
Appeal by KSRTC. Only on the issue of quantum, the case of death.
1 minute. Where is the table? Which year is the accident?
Accident is of the year 21.
How much is the income considered by the court?
The court has calculated 14,000.
14,000. It should have been?
75-year-old man. Paragraph number 11.
If it is 2021 is the accident, as per the notional income, it is 15,000.
My submission is, my lord, he is already 75-year-old. 70 was.
If he is 75 years old, will not take the future prospect.
Yes, the court has, the tribunal has not taken it.
So now, and what count the amount has to be reduced?
Lord, since there is no multiplier after 70, Lord, it's a guesswork. Lord, I leave it to the court. But my submission is, as such, my lords, for a person who is cross 70, This table or a guideline, whatever it is.
How is it generally done? Loss of dependency, some multiplier, whatever is that fiber, that is the.
For 70.
So that is
Because
what is
postmortem
applied.
report clearly says that he is 75-year-old. The tribunal has taken 70. Therefore, I said. Normally, your lordship will consider whatever the age which comes in a postmortem report.
Hmm.
There's another aspect is
Huh?
the two daughters. Two daughters,
Or not dependents.
not dependents. They are married and they're residing elsewhere. They cannot become.
What we do is, what is the age of the daughters?
One is 46 years, another is 45 years.
What we can do is we'll deduct once instead of 1/3, we will deduct half.
1/4.
Oh, the issue is about the multiplier.
The tribunal has taken 1/4, my lords. It ought to have been 1.
We will take half.
Please.
So if we take half, so how much is now the income has to be taken at?
My submission is 10,000.
No. It has to be more than that. 2021 it is 15,000. Court had taken how much?
14,000.
14,000. Half would be 7,000. 7,000 into 12 into 5. It comes to 4,20,000. And 88,000. 36,000. And then say love and affection 80, funeral expenses.
But consortium and love and affection will not go together. Normally.
What are all these grounds? What are all these heads? Where is it is parted? Last time also is not there, I think.
Not there. The interest will be 6%, 9%.
So 4,20,000 plus 88,000 plus 36,000. It comes to 5,44,000. Any claimants appeal in this for enhancement?
No. No, my lords.
The agreed with award passed in MVC number 949 of 2021, dated 12th January 2023. The corporation is before this court questioning the quantum of compensation. It is submitted that as per the postmortem report, the age is 74 and 75 and the court had taken 5 multiplier. Further, the income is taken at 14,000, which is on the higher side. Apart from the loss of love and affection, the court had granted again another 50,000 on loss of consortium, and again an estate and funeral expenses, and all those heads are not available for the court for granting compensation. Next para. On the last occasion the matter came up, there was no representation on behalf of the respondent, and this court has heard the counsel for the appellant and posted the matter today under the head part. Today also there is no representation, and this court is proceeding to pass orders on to the matter. The tribunal had considered the age of the claimant, age of the deceased as 70, and this court finds no reasons to deviate from the same. Considering the income was considered at 14,000, and as the tribunal ought not to have considered them as defendants, the two were aged 48, 47, and 52. Who are all the three?
The 2 wives. First one, Hasmatunisa, wife of Muhammad Musa.
I was thinking that only there are the daughters are there.
No, I'm only saying respondent number 2 and 3, and that means claimants number 2 and 3 are daughters.
One is the wife.
One is the wife.
If wife is there, it is only 1/3.
Wife is there. Therefore, my lords, your lordships have taken off.
No. Wife is there. How can it be a half? It is 1/3. 1 to 3 is 1/3.
Oh, yes, my lords.
Then 7,000, 14,000 to 1 is it comes to 9,03,033 into 12 into 5, it comes to 5,60,000. 5,60,000, 88,000, 36,000 plus 88,000 plus 36,000. It comes to it comes to 6,84,000.
Please.
What did you write? It is submitted that the daughters were also considered as dependents and 1/4 is deducted on third.
Correct.
On
1/4
third,
is deducted by the tribunal.
1/4 is deducted. It is submitted that the daughters could not have been considered as dependents, and the compensation that is awarded is on the discussion or you come to the order. Same with regard to the respondent submission. This court has perused the order passed by the tribunal. The claimant this court is taking the age at 70 years, and the first respondent is a wife. The first claimant is a wife, and the other claimants are two claimants are daughters, and who are aged
46 and 45 at the time of accident.
46 and 45 at that point of time. And this court considering only the wife, and here three also, one more also will, another 44,000 will add, because there are three.
Another wife, only as far as two wives are there.
No.
Claimant number 1.
Why? What is this loss of love and affection? Why one wife is entitled? Even he is entitled to have two wives there.
They can they go for 3 wives also.
That
I
will
should not be
also-
saddled with.
No, please wait. It will come to 1,76,000 towards consortium. 1,76,000 plus 5,60,000
Then it comes to say.
plus 36,000. How much it is coming to? 7,72,000. What is awarded?
8,10,000. A marginal.
Marginal difference. What did you write? Two. The wives are the two wives and the two daughters, or the claimants. The daughters cannot be considered as the dependents, and hence 1/3 is deducted towards personal expenses. The salary is taken at 14,000. 1/3 is 4,666, and this contribution to the family would be 9,333 into 12 into 5. Loss of dependency would come to 5,60,000. 4 are the dependents under the head of consortium. 4 into 44, 1,76,000. Funeral expenses 36,000. It comes to 7,72,000. Accordingly, the appeal of the insurance, the RTC is partly allowed, reducing the compensation from 8,10,000 to 7,72,000. The amount shall carry 6% interest.
Great.
Bill number 4.
Which one? Serial number? 1 minute. 40?
47.
47.
1 minute. 47, it is submitted that the corporation is ready to pay an amount of rupees? 5 lakhs lump sum. 5 lakh lump sum in addition to what has been awarded by the tribunal for filing memo tomorrow, for filing joint memo tomorrow.
At 5:30 for Lokadal.
Yes.
HR Renuka will be ready to take notes.
Huh? Tomorrow 5:30 we are having the Lokadal. Tomorrow we are having evening 5:30.
There's no need for us to prepare.
No, the joint memo generally what is like Lokadalat, how it was the same thing.
Because in labor matters, we were asked to do. We settle on Saturday.
No, Raghu is
Cases.
no. She knows what it is done. That's what that way you can do. Yes, next.
HR Renuka takes notice for the
Next 4.
Cell number 4.
One week time will be granted. Your Honor.
What 1 week?
R2 fresher.
Yes, what about this Renuka? MFA.
R2 ಗೆ fresh address. R2 ಮನೆ ಖಾಲಿ ಮಾಡಿದ್ದಾರೆ ಸರ್. That's why I'm asking time. I collect the fresh address and then I take the.
What is awarded?
Otherwise I'm.
Look at it.
R2 is how much?
How much is awarded?
ನೀವು ಹೇಳ್ಬನ್ನಿ.
There is no urgency. It may be taken after vacation, madam.
No, they are ready to pay. No, how much is granted?
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
No, court had granted only 7,395 and you are ready to pay?
Global 10,000.
Global 10,000.
Global 10,000 is.
In addition to this?
In addition.
In addition to this?
No, madam, it's interest. Interest part and all the litigation charges will go more, madam.
They're not in 2009 accident. Those days simple injuries only that much was being.
They tell that is a simple injury, my lords.
Tomorrow get instructions.
Please.
Because you will not get a better amount than this.
Please.
Yes. Tomorrow, part third. Yes, next 5.
For the respondent, my lords. Corporation appeal.
Any scope for settlement or judicial order?
Well, probably judicial order, only on quantum, the death, the case of the corporation is death has no nexus not to the injuries suffered. Well, the date of accident is it's 17/11/2000.
Any point on that? With regard to nexus, any arguable issue? Or
Yes, ma'am. Yes, ma'am. If your lordship could see the dates, my lord, I'll only give 3 dates. Only 3, my lord. 17/11/2014 is the date of accident.
And for dismissing it, we can wait till vacation. If any relief to be granted, we can do it now.
Yes, ma'am. After vacation, it could.
Yes. Next, it is appealed by KSRTC. What is it? 16. 6. MFA number 2690.
Cell number 6.
Payment is not served. Notice to the respondents to take steps within a week.
Cell number 7. P. Pala. Then
National insurance. That I cannot appear against there's conflict of interest in. I'm the counsel for both companies. Respondent number 5. National insurance company.
No, you're directed to take notice for?
National insurance company.
We'll ask somebody else. Who is the national insurance company?
Manjula.
Huh? Manjula so and so is directed to take notice on behalf of the insurance company. Delete the name of HR Renuka. Next.
Cell number 8.
Notice.
Steps. Notice.
For taking steps a week's time. Next also a week's
Cell number
time.
9. 1 week. Cell
10.
number 10.
1040 consent order.
1,40,000.
1,40,000.
40,000.
global, in addition to what has been awarded memo tomorrow. Yes, 11. So Renika is there to take notice on behalf of the KSRTC. Yes,
Cell
next
number
11.
11.
Appeal for appellant. 8 years old child, madam. Injury case. Grievous injuries sustained in accident.
If you want Master Mallikarjun to be applied, we'll decide. Or else you have to wait for that order to be passed for the pending matter in Supreme Court.
Now my instructions are to go ahead with them.
Go ahead with the matter. Yes, we'll apply Master Mallikarjun. How much is disability? Give the fine. How much is the disability?
Disability is, my lord, 10%. 10%
That
they have
is 1
taken.
lakh only.
Yes,
Towards
ma'am.
pain and suffering. Medicines,
But-
any amount?
But age of the child, my lord, and the future.
Oh, that's what I'm saying.
Yes, ma'am.
No, for that disability, if you want Master Mallikarjun to be applied, as per the table only we can do.
Yes, ma'am.
Or if you say that any notional income to be taken and all, that this code is not doing it now.
Yes, ma'am.
Loss of earning to the parents 15,000, medical expenses 10.
Where is the
Conveyance, food and nourishment 10, my lord. Attendance charges 10.
How many days they were in hospital? That we will
15
see.
days, my lord.
So
15
loss of earning to the parents, 15,000 is granted.
Yes, my lord. And
Which year is the accident? 2018.
18.
2018.
We have written another
12,500. There we can increase little bit, I think.
Yes.
If you grant for 12,500, 12,500, it will come to 25,000. So here 10,000. Medical expenses, and you're facing on that, it is granted. Conveyance for 15, we can have 15. No, put together it is granted already 20.
That's why 20 in addition we have written, my lord. Because
Then
9,
1 lakh.
9% interest is granted.
Maximum, what can be enhanced is another 10,000.
We have written 20, my lord. 20, we have written, we are offering 20, my lord, lump sum.
Yes, my lord. I'll seek instruction. Tomorrow it may be. I'll seek instruction.
There can't be enhancement more than
Yes, ma'am. I'll
only
instruct
in
the
loss
parties.
of earnings to the parents, another 10,000, 12,500 will
Yes,
be
ma'am.
awarded.
Please, ma'am. I'll
Yes,
seek
tomorrow.
instruction.
Yes, next.
Take notice.
Same, Renika is directed to take notice on behalf of the respondent. In all these matters, wherever directed, the registry is directed to print her name. Yes, next.
As parted tomorrow.
Tomorrow.
Parted. Cell number 12.
I for the appellant in this case, madam.
Jagdish.
I for the appellant in this case, madam. Copy has served the HR income, madam. The tribunal has awarded 20 lakhs 91,000 is awarded. The doctor assisted disability 50% to the whole body, madam. Loss of
Case of
injury, madam. Loss of future prospect may be added by the matter.
What is the disability? How much percent?
50% of the whole body.
Then we have to take judicial order.
Already served the copy.
It's a fresh matter, my lord. He gave me the copy on Saturday.
We'll have it on second then.
Yes.
We'll have it on second.
Please.
In the meantime, let them also look into it. Yes. So Renuka is directed to take notice on behalf of the respondent corporation. This is matter on Tuesday. Print her name. Yes, next.
As parted.
19.
Cell number 13 to 18 urgent.
Yes,
19.
19.
For the appellant in this case, madam.
19, 19, my lord. By consent, 7 lakhs.
7 lakhs. It is submitted that the insurance the corporation is ready to pay an amount of 7 lakhs lump sum in addition to what has been for joint memo tomorrow.
Tomorrow.
Okay. Yes, next.
Cell number 20. 20.
Appeal for appellant, madam.
What about this?
Shiva Kumar.
We didn't have the file, my lord.
In 20? You
I'll
go
serve.
for-
I'll serve.
Look at it.
Yes,
No,
ma'am.
or else, no, we'll have it tomorrow.
Yes,
In the
madam.
meantime,
Please.
tomorrow you can talk to
Please,
her
ma'am.
also. Does this matter tomorrow as part her? Yes, next 21.
21.
Print the name of HR Renuka. Renuka is directed to take notice. Delete the name of T. Vijay Kumar. Next 21.
I appeal for appellants, my lords. It's a case of injury.
Yesterday's matter.
Yes, my lord.
Seeking, awarded amount is 3,311, my lords. Seeking enhancement,
11,265 plus 6% interest.
In addition,
We have
1 lakh,
1,11,265. Your lordship could round it up, 1,12,000, my lord.
1,12,000.
Plus 6% interest.
6% interest in addition to what has been awarded. I'll post this matter tomorrow for filing a joint memo. In the
I'll
meantime, you
seek
can get
instructions, my
also.
lord.
If you're ready, you can file a joint memo.
No,
tomorrow.
yesterday also they said they would seek instruction. It is better to call whoever.
My lords, this offer has been increased than Saturday, so I will have to seek instructions.
No, where is your senior?
My lords, she's held up with the other matter.
1 lakh, it is submitted that the insurance company, the corporation is ready to pay an amount of rupees 1,12,000 in addition to what has been awarded at 6% interest. This is matter for filing joint memo tomorrow before the Lok Adalat. Is 22?
Bill number 22.
Macho.
Sumar
Is 22?
22.
What about this? They want to, or we'll have it after vacation. This is matter after vacation.
Bill number
Next
23.
23.
23.
Yes, 23.
We are offering 25,000 global.
Who appears?
That is Banu Prakash HV.
Rajshekhar is,
His counsel for corporation, I'm representing him.
yes.
Rajshekhar is the counsel for,
Banu Prakash,
he's the climate editor.
is it agreeable for them?
But he's not come.
It is submitted that the insurance company, the corporation is ready to pay an amount of rupees,
Global compensation of 25 million.
global compensation of 25 in addition to what has been awarded for filing joint memo tomorrow, Lok Adalat. To the, both the matters. Yes, next.
Yes, ma'am.
24.
Cell number 24.
In my appeal, but I have served the copy to the petitioner's appellant's councilman Sukumar.
Then we'll have after vacation.
His name may be shown, madam.
Huh?
His name may be shown in my appeal.
For 24.1, Mr.
Yes.
Shivkumar P is directed to take notice on behalf of the respondent and his name shall be,
Records
shall
may-
appear in the cause list.
And records may be called, records may be called forward. Records.
Okay. Call for the TCR. Yes,
Cell
25.
number 25. Ganesh R.
Appellant. Case of enhancement for by the claimant, injuries case. Claimant is the second year engineering student.
1 lakh global is what we are
1 lakh?
agreeable. 1 lakh.
Yes, 1 lakh global.
His disability has not been considered by the disability has not been considered with.
No, that's what they're coming up with 1 lakh.
I will tomorrow. Please.
The corporation is ready to pay an amount of rupees 1 lakh globally
Please.
in addition to what has been awarded in the, for filing joint memo tomorrow, 5:30 before the Lok Adalat.
Grateful.
Yes,
Cell number
26.
26.
26 is 1,03,000 global.
It is agreed? They're not there, then I'll let them come. 1 lakh. Oh, after vacation. I didn't see that. After vacation. Yes,
Cell number
27.
27. N. Kumar.
50,000 plus 6% interest.
It is submitted that the corporation is ready to pay 50,000 in addition to what has been awarded at 6% interest.
Cell
Tomorrow
number
for so and so. Yes, 28.
28. B. Palakshaya.
What about 28?
28, 2,30,000.
2 lakh?
30,000.
2 lakh 30,000 lump sum in addition to what has been saved for tomorrow. Yes, 29.
29.
It's okay for appellant, my lord. The insurance company is there, my lord. New India Insurance Company.
Bill is there after vacation.
Cell number 30.
Kindly follow along with NFA 7421 of
On
after
liability
vacation.
after vacation.
And kindly follow along with 7421 of 19 1.
Post along with so and so.
7421 of
Put on a paper and give. That's the whole problem. 31.
Cell number 31.
Appearing for the appellants, your lordship. Your lordship, the senior is out of station. If it may kindly be taken up after vacations. Your
Any
lordship.
amount you're globally? 4,50,000 lump sum compensation. Tell your senior tomorrow for filing joint memo.
Indeed,
They're ready to pay 4,50,000 in addition.
Your Lordship. Much obliged, Your Lordship.
Shell number 32. 32,
32,
Lalita P. Anihan.
liability after vacation.
Shell number 33. Raju S.
Appellant. Appearing for the appellant. Praise time.
Huh?
Praise time. After vacation.
What about 33? Give the fine.
Nimdala? No.
After vacation 33. Yes,
Shell number
34.
34.
On liability.
Renuka HR. All are
Can I do this, man?
Yes.
My lord, only the ground is, my lord, that towards loss of dependency, my lord. 1/4 has been deducted.
How many are?
My lord, the 2 to 5, the deceased was 65 years and claimants 2 to 5 are the major children, my lord. And deduction that is made is 1/4, my lord. My lord, the date of accident is 2017.
No, looking at their age, we have to see what is the evidence. Same that she, what is that? Sheetal, for to apply Sheetal's case. Seema Rani's case, not
My lord, they are 41 years, 40.
No, 38, 37, 35.
Yes, my lord.
What is their pleading
Pleading, my lord.
with regard to the dependency?
Yes, ma'am.
And what is the other evidence? If they don't, they're not saying that they're dependent, it's a different issue. Have the record?
Yes, my lord, I have.
Look at the claim petition.
My lord, they don't say that they were dependent. Can I just, my lord, I'll, what it is stated here, my lord, is that the claimant says that 2 to 5 are the children or my
Or in
children.
evidence, what is elicited?
Evidence only I'm reading, my lord. Evidence. Then she says that the deceased Ramana was taking care of the entire family and they have deprived of love and affection. And she has lost her husband in a young age. And the respondent number 2 to 5 have lost their father and have lost love and affection.
That is
And
mother's.
that's all.
What you're reading is mother's.
Yes.
Wife's.
Wife, my lord. I'm reading the wife, Rukmini.
Daughter.
They have not led evidence. They have not.
What else she's saying?
And she says that, my lord, they have placed in financial difficulties on account of his death. He's the breadwinner of the family.
So,
Except this, my lord, there's nothing else.
Entire family is depending on him. No contra evidence that they are not depending.
No, what we have said is that they have the, as per Exhibit P9, there's RTC, extract is produced. And all that is, my lord, lost to the family is the supervisory amount, my lord. Because the land remains, my lord, for, that's the judgment of the apex court, my lord.
Seema case is altogether different.
And they can't be held because they're all married, my lord, children. They can't be held as.
Not necessary that all the time.
And the day on which she gave evidence, she was.
Married sons and married daughters are not dependent on parents. It all depends on the facts. That's how it's discussed.
My lord, no, they don't say.
At least we can understand, like between like the age is all in there and all in 30s.
My lord, they don't say, my lord. She doesn't say that they were depending on.
So what you read?
No. What she said is that on account of my children 2 to 5 have lost their father and lost love and affection.
So my view on this is
and full stop.
Looking at that age.
After.
Yes, after vacation.
Shell number 35.
Lords, for the appellant in this matter. Lords, we are challenging the quantum, my lords. The salary.
Which one?
Same thing. Your lordship,
34. The insurance, the land council appearing for the corporation seeks permission to withdraw the petition, take the second signature. Is 34.
Then it has dismissed as withdrawn. So Lakshmi says, probably your lordship interfered because she was 70 years. That time he did not.
That's right.
Otherwise, he had written it as to withdraw. So,
No, in the other case,
75 years, I think.
50, their ages are like that, 50 for 47 daughters.
Cell number 35.
For the appellant corporation, it's challenging the quantum.
What about this 35?
Banaprakash HV.
That is a plain petition.
The plain petition, they have pleaded, my lord, as 12,000 per month. But exhibit P13 shows that the salary is 9,868, including 1,775 as OT, my lord. Including OT, it is 9,868. The tribunal takes it as 12,500.
Case of death or injury?
Yes, death, my lord.
Death, my lord.
Court had taken how much?
12,500.
12,000.
Sorry, 12,000.
12,000.
12,000.
So
He was a
according
daily
to
wage
how much
earner,
would
my
be
lord.
taken?
My lord, it's
They themselves
9,000.
produced exhibit P13.
You know, your appeal is not there. So whatever court has
No,
taken.
no, our appeal, my lord.
Our appeal, my lord. Corporation's appeal, my lord.
Corporation appeal, my lord. 35.
Oh, it is.
I'm so sorry. He's arguing, my lord.
My senior, ma'am. Please.
I'm so sorry, but the claimant is not there. Claimant ilvalla. Nan odidini. I've read the papers. My lord, the claimant, only thing is, my lord, only on quantum, my lord, exhibit P13, my lord, if your lordship takes.
This is matter as part her tomorrow.
Yes.
For the counsel for the corporation, no representation for the respondent. Yes, 36.
Number 36.
Exhibit P13.
Chandrasekhar KA.
What about this 36?
Number 36. Chandrasekhar KA for appellant.
File is not there. This is matter after vacation. Yes,
Cell number
37.
37.
Claim petition is after vacation. 38.
38. B. Palakshaya.
You are offering 3 lakh 1,000 as against 3 lakh 61,000. 3 lakh 1,000 plus 6% interest you are offering as against 3 lakh 61,000 of 9%.
It is submitted that the respondents are ready to pay an amount of rupees 3 lakh 1,000 against the awarded amount of
3 lakh
61,000, interest at 6%. Huh?
As against 9%.
Yes, for filing joint memo tomorrow.
Cell
39.
number 39.
Yes, 39.
Cell number 39. Pramodar.
39. File is not there.
If it's there, we can negotiate. I'm appealing.
He's saying something.
No, she says that I'm appearing in this case. Case is interested.
Yes, tomorrow.
Tomorrow. As parted, ma'am.
Yes, 40.
My lord, in this 40, there is no disability and all are simple injuries. Lower court has awarded 1,08,000. 50,000 more, my lord, we are ready to.
So it is submitted that globally.
No disability and global 50,000.
Since the corporation is ready to pay an amount of 50,000 in addition to what has been awarded. List is matter, same for local alas, the filing joint memo.
Cell number 41.
But they are not present. Today they are not present.
Tomorrow, if it is listed, they will come, they'll look at the order, what is there. If they are ready, we'll come, or else we'll post it before the court. It's 41.
41.
What about 41?
K. Prasanna Shetty. F.S. Dabali.
File is there. Tomorrow. 42.
Cell number 42,
After vacation. Yes, 43.
43,
This is also after vacation.
cell number 44.
Yes,
I'm
44.
appealing for the appellant, my lord. My lord, there are two contention, my lord. One is deceased is the deputy tahsildar, negligence. And another is medical expenses already claimed in
Is
state
after
government of
vacation.
Karnataka, my lord.
Cell number 45.
45, I appear for the appellant, my lord. In this case, the injured is a salaried lady, and she lost the leave surrender encashment benefit for 3 months, and nothing has been awarded towards loss of income during laid up period.
Yes, any calculation on 45?
Her salary was, my lord, gross salary was 53,000 and odd, and net salary is 36,000.
The total amount comes to 15 years for 80 years, comes to 2,90,230.
2,90,235 globally. Have you heard? They are ready to pay 2,90,000 globally.
Yes, I am agree.
It is submitted by the corporation that they are ready to pay in amount of rupees 2,90,000 globally. In addition to what has been awarded by the tribunal, and the parties will file a joint memo. This is matter tomorrow.
Yes,
46.
46.
My lord, in this case, I appear for the appellant in this case, my lord. The appellant was traveling the tractor and trailer, my lord. He failed to prove that he was traveling at the time of accident.
1 minute.
Yes, ma'am. Yeah, sorry, madam.
Sriram General, where are they? Where is Pradeep? This is matter tomorrow as part heard.
Yes, much obliged,
Number
madam.
47, I'll refer to
Adjourn
local
48.
address. Number 48.
48.
I appear for the appellant in this case, my lord.
Cell number 48.
Yes,
My lord, I
yes.
appear for the appellant in this case, my lord. It is for injury case.
Any calculation is done in this?
KSRTC. No future expenses has been awarded. No.
They are ready to pay 85,000 in addition to what has been awarded by the tribunal.
If you take it up tomorrow, my lord, I will come back.
Tomorrow. It is
Please.
submitted that the corporation is ready to pay 85,000 globally.
If you take it up tomorrow.
85,000 in addition to what has been awarded at 6% interest for filing joint memo tomorrow before the local adalat. It's 49.
Cell number 49. Ashok and 9.
After vacation, ma'am, because another connected appeal filed by them also. I'm not.
After vacation.
Cell number 50. Arun KS.
Appear for the petitioner.
MK.
For settlement, they are asking only 30,000, my lord.
How much you want?
2,50,000, my lord. My lord, for permanent disability, they are taken only 10 per my lord.
There
But
can't
that
be
is 17%.
Can't be
17%.
any negotiation between 30 and 2 lakhs. 2 lakhs.
Sorry, my lord, they are calculating, my lord. Only they are taking a permanent disability 10 per my lord. But
What
that
is
is
the evidence
17
of the
per
doctor?
50 per of that, madam. At least 1/3 of that they have to take, madam.
So how much it comes?
17%.
They are taking?
10%.
That's why it is settlement.
No, my lord, only 30,000, my lord. It's
After vacation.
Cell
Yes,
number
next.
51. KL Srinivas.
What about this?
Lalita PM. इधर 51, ma'am.
Global 20, joint memo tomorrow. Yes, 52.
52. Cell number 52. Sangamesh Sharbi.
I think this insurance companies are also there. This is matter after vacation. Yes, 53. No, that is there so many. It will not be settled. Next matter. 53?
53, after vacation, insurance company and
After vacation.
Cell
54?
number 54.
Withdraw. It is submitted that the corporation wants to withdraw the petition and a memo is filed. And a memo is filed in this regard.
Yeah, these
Memo is
photos.
taken on record and dismissed as withdrawn. In the earlier matter also give that memo. Is 55?
I appear for the appellant, my lord. Kindly have it next week, please, for discussion. KSRTC is not applied for loss of revenue. That's the only point.
You give the memo. Advocate memo will be sufficient. Write it and give. Yes, 55?
Cell number 55.
I appear for the appellant, my lord.
What is the issue in this?
The only ground is KSRTC is not entitled for loss of revenue, keeping the bus idle.
Yes, sir.
That is the only
vacation.
ground.
Cell number
After
56.
vacation, 56.
RV Shivanand Reddy.
What about 56?
Appearing for appellant, it can be posted tomorrow.
Let us see what is there if they have any offer. They are seeking enhancement after vacation.
Cell
Next,
number
58.
57.
57.
57.
What about
H. Pandey.
57 by the RTC?
Claim dismissal.
After vacation. 58.
58. Gurdev Prasad Ketty. Rajshekar.
On negligence. After vacation. Is
Cell number 59.
I am for the appellant, my lords.
What are they saying? 21,000 in addition and 6% interest.
And he has been hospitalized 21 days inpatient, and he has undergone operation also, my lord. He has, occipital bone fracture.
But enhancement will not enter because 3,67,000.
No, according to you, under which head you are entitled for enhancement?
My lord, medical expenses itself is 2,46,000. In 3,67,000, medical bills itself is 2,46,000. So under pain and suffering, only 50,000 has been granted, my lord.
On injury.
Yes, my lord, that is also
On injury?
occipital bone fracture involving skull base and also grievous injury and right knee. Right knee.
50 lump sum.
With interest. Because loss of
In addition
immunity.
to what has been awarded.
Loss of immunity. 10,000 koti. 10,000 koti. 1 lakh. 1 lakh is.
Hmm? 60,000 lump sum in addition to what has been awarded by the tribunal. Joint memo tomorrow.
And Millard,
No, even
let
if
it
the
be
time-
after vacation, Millard. Let it be after vacation.
After
Because
vacation, if you're not interested.
I'll get the wound certificate and discharge.
After vacation, after vacation.
Please, much.
Yes, next.
Cell number 60. Lokadala. Cell number 61.
After vacation,
Cell number 62.
I think this is by the corporation.
Dubali.
After vacation,
Cell number.
so shall we have it tomorrow? So from 63 tomorrow. It's- Huh. Yes, give the court file tomorrow to them. 63 to 17.1. Any other matters for tomorrow?
Challenging the liability, my lord. That's it. May not,
No, they are saying they don't have the files to.
They may have-
What is liability?
they may have to withdraw the case because the amount calculated at the rate of 9,000, 2018 interest ought to have 12,500. I have not filed appeal.
That number.
66.
And also give the file, they look at it, if they want to withdraw, they'll withdraw.
Serial number 68, my lord.
68.
Future prospect is to be concerned.
No.
The injury is
got it, then no scope for
injury
that.
to spine, my lord. Only injury to spine. Only 10% is taken.
After vacation.
After.
68. After vacation.
Yes, ma'am.
Remaining matters continue tomorrow. Huh? Which one? Which one? Other matters are coming tomorrow.
My lordship, serial number 63, one submission, my lordship.
63?
My lordship.
Ah.
The appearing for appellant undergone with surgery, my lordship, skin grafting tissue surgery. Kindly have it on after vacation, my lordship.
63 after vacation. Remaining matters tomorrow. Yes. What? Yes, yes, we don't have to have such a big list. No, I'll read. It's a big one. Get it to the same. So, how the joint memo is, how the joint memo, it was recorded, tell David.
Not be present on Saturday. There were labor matters, 140 matters.
That's what I'm told.
But we could settle 102 cases.
100.
Labor matters, labor settled like this, 102 cases. We went on till 6:45 or 2:30. So sorry, madam, that's why.
No.
And I had settled some cases and I had not informed the law officer about settlement. Only that day is Saturday.
She was not aware, she was a little confused with the list also.
Sorry.
No.
ನೀವು ಹಂಗೆ ಮಾಡಿ ಏನೋ ಕೊಡ್ತಾರೆ.
Withdrawal memo, can I give it tomorrow? I have 4:30 local as
Tomorrow in those two matters. So take and keep it in the file.
one case is mine, madam, the other case I'm taking.
Sixty-one after vacation. ಹೇಳಿ ಮೇಡಮ್ ನಂಬರ್ ಹೇಳಿ ಸರ್. ಆಯ್ತು ನಾನು ಕೇಳ್ತೀನಿ ಕೇಳಿ ನೋಡ್ತೀನಿ.
ಮೇಡಮ್ ಅಡ್ಮಿಷನ್ ಆಗಿರೋದು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡ್ರಾ ಅಲ್ಲ ಅಡ್ಮಿಷನ್ ಆಗಿರೋದೆಲ್ಲ ಅಡ್ಮಿಟ್
ಕೇಳ್ತೀನಿ ನೋಡ್ತೀನಿ.
ಜೊತೆ ಕನೆಕ್ಟೆಡ್ ಅಪೀಲು ಅಲ್ಲಿ ಮೆಮೊ ಫಸ್ಟ್ ನೋಡಿ ಮೇಡಮ್ ಕಳಿಸಿ ನಾನು ಮಾಡ್ತಾ ಇರ್ತೀನಿ. ಬಿಂದು ಮೇಡಮ್ ಕಳಿಸಿ ಸಪ್ರೇಟ್ ಮಾಡ್ತಾ ಇರ್ತೀನಿ. ಸೆಕೆಂಡ್ ಮೇ ಒಂದು ನಿಮಿಷ ಮೇಡಮ್
GM ಬ್ರಾಂಚಾ? GMFC? ನೋಡ್ದೆ ನಾನು ಮ್ಯಾಮ್ 29 4th ಪೋಸ್ಟ್ ಆಗಿದೆ.
ಯಾವ ಬ್ರಾಂಚ್ ಎಲ್ಲಿದೆ ಫೈಲು ನಿಮ್ದು? ಯಾವ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ? ಅವರು ಗೌತಮ್ ರಘುನಾಥ್ ಫೋನ್ ಮಾಡಿದ್ದಾರೆ. 29ನೇ ತಾರೀಕು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಂತೆ, ಅವ್ರ ಬ್ರಾಂಚ್ ಅವರು ನಮಗೆ ಮೆಮೊ ಬಂದಿಲ್ಲ ಅಂತಾರಂತೆ. ನಾವ್ ಇಲ್ಲಿ ಮೆಮೊದಲ್ಲಿ ಬುಕ್ ಅಲ್ಲಿ ಬರ್ದಿದೀವಂತೆ 29ನೇ ತಾರೀಕು ಅಂತ.
ಅವರು ಅಲ್ಲಿ ರಿಸೀವ್ ಮಾಡಿ ಇಲ್ಲಿ ಮೆಮೊ ಬುಕ್ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಮೆಮೊ ಇಲ್ಲ
ಇಲ್ಲ ಅಂತಾರ.
ಮತ್ತೆ ಇಲ್ಲ. You see the memo book. Some of his colleagues came and verified that.